Apologies. Okay, Mr. Bo, would you
Yes,
like to continue?
Thank you. Before continuing where I was up to yesterday, I'm just going to, with your permission, going to just summarize, because we covered a lot of ground yesterday where we're up to, and I'll also pick up on a few points that were raised yesterday. I mean, essentially, we say there are really just two issues in this appeal. The first one is, does the court have essential jurisdiction to make an order in support of foreign proceedings? And the second question is, did the judge exercise his discretion appropriately when excluding the defendants from making any submissions other than in relation to essential jurisdiction? And we say yes in relation to the first question and yes in relation to the second question. So in terms of essential jurisdiction, I'm going to summarize our position very, very briefly. We start with the JAL, which I won't take you to. We're not looking in the DIFC at in personam jurisdiction. That word doesn't really have, or that term doesn't really have much meaning outside the JAL. The question for the court is always, does the case fall within one of the gateways in the JAL? We then, and we are of course relying on JAL 1A, 1E. So we need to identify a DIFC law and DIFC regulation, which gives the court power. And we say we've done that because looking at the court law, I took the court yesterday to Article 22, where the court of first instance, which says where the court of first instance may order an injunction restraining a person from engaging in conduct or requiring a person to do an act or thing or other order that the court considers appropriate. Now, one point I wanted to highlight today is that the section is headed, where this appears, is headed jurisdiction of court of first instance. So it is a jurisdiction provision. And this gives the court unqualified power to make injunctions, including in support of foreign proceedings. I also drew the court's attention to Article 32 of the court law. We also looked briefly at NEST, which is authority for the Court of Appeal authority, for the proposition that rules of the DIFC court can be considered DIFC regulations for the purpose of the JAL. And so we looked at those rules of court. I took the court to RDC Rule 25.11, which is where the court is given power to order interim injunctions. 25.16, where the court is given power to make freezing orders. And RDC Rule 25.17, where the court is given power to require a party to provide information. And all this is without qualification. We also looked at Rule 25.4, which simply says a judge may make an interim order, again, unqualified power. And we looked also at RDC Rule 25.24. And we had a discussion about that. And what the Chief Justice, and I believe Lord Glennie put to me, was this clause is simply a how-to clause. It doesn't deal with jurisdiction per se. Now, you recall that clause was, or that provision was dealt with in Jones. And I just want to look back at Jones because I do think it actually repays some careful reading. So if you go to page 1178 of the bundle, and in particular, paragraph 8. Do you have that?
Yeah.
So it says that reliance was placed on Rule 25.1 and 25.24. So 25.1 we've dealt with. And then it cites in the case here 25.24. And then a 9 is the reasoning that we were looking at yesterday. It says, it is clear that this rule envisages interim remedies where no substantive claim is being made in the DIFC, and the purposes of the relief sought relates to proceedings elsewhere, which would include the Dubai court. As was pointed out by counsel for the claimants, if jurisdiction arose under one of the gateways in Article 5A, 1A to D, there would then be jurisdiction for the substantive claim itself. Now, what my learned friend was saying is it's possible that actually this only applies where the court already has jurisdiction under JAL 1A A to D. And the point that at least I missed yesterday was that actually the court would not have jurisdiction. For example, let's take the example of a body corporate, so a company in the DAFC. The DAFC court does not automatically have jurisdiction over that company without there being a claim against that company. And the reason I say that is because if one looks at the JAL, the wording of the JAL itself says that jurisdiction, the court will have exclusive jurisdiction where there is a civil or commercial claim against, for example, a body corporate or against a party to a contract. And so the reasoning here in relation to 25 to 24 is that this is a situation where there cannot be, or there is not, jurisdiction under any other of the gateways other than E, because there is no claim in the DAFC, because the claim is outside the DAFC, and actually it could even be a prospective claim outside the DAFC. And therefore, this has to deal with a situation where there is no claim in the DAFC, there's no jurisdiction. Therefore, the only way this could come about is under the gateway JAL 1A 1E.
Can you remind me where the JAL is on the documents?
Yes, it's 6622, and we should of course look at that.
6622.
Yes. So you can see 5A1, it's the civil or commercial claims and actions. And that wording is repeated all the way to E. But E doesn't have that wording. E has any claim or action. And indeed, an application for an interim injunction is an action, or more accurately, it's an application. And that's why that argument was made by Mr. Montague Smith, and it's a clever argument. He'd no doubt like me saying that, but it is a clever argument. And in fact, it's supported also if one looks at the court law, and His Excellency Mr. Madhani, His Excellency Madhani yesterday pointed me to this. If you look at 6516 of the bundle, so that's the page, sorry, 6516, which is the court law, and it's 19, Article 19 or Section 19. So you can see there, if you have that, again, you've got the civil commercial cases listed A to C, and then D, which is the relevant part for our purposes, is any application, which is we would submit more specific and actually exactly goes to the heart of what this is about. It's an application. And so we do say that RDC Rule 25.24 supports, but not necessarily gives the court jurisdiction. The court's given jurisdiction by the court law that we looked at, the provisions in the court law, and also the other rules of the RDC that we looked at, but it certainly supports the proposition that a court can make an order against, in support of foreign proceedings, without there being other jurisdiction under the gateways, under the other gateways.
You're referring to D, are you, Mr. Bob?
Yes.
Okay, let's read D slowly. Any application. 19.1D, I'm reading 19.1D. Any application of which the DIFC court has jurisdiction.
Yes.
It presumes that it has jurisdiction. The next question is, where does it derive that jurisdiction from? DIFC laws or regulations?
Correct. And the answer to that,
it presumes there is jurisdiction, laws or jurisdiction. One of the laws or jurisdiction that 19.1D must be referring is JL. Right?
Yes.
Yes.
It's JL, now, but yes, sorry. Sorry.
Now, regulations. What are the regulations which confers jurisdiction on the IFC court?
Yes. So that I believe I've already answered. It's Article 22 of the court law, Article 32 of the court law, RDC Rule 25,
Article 22
of the
and
court law, Article 32 of the court law.
It's helpful, Mr. Bohr, it's helpful if you pause so we can actually look at each rather than rattle them on and we never get to this.
Okay, I'm sorry. The only reason I rattle on is because I did go to yesterday, but I understand that we're dealing with a lot of material. So if we can go to 6508. Yes.
Okay.
So this is the court law.
Yes.
And then you can see it's part 5 is headed jurisdiction of the DIFC court. So you see that?
Yes.
At page 6508. It's just a contents page.
Yes.
Yes. Yes.
And so the heading is telling you that whatever's in this chapter 1 deals with jurisdiction. And so if we scroll down now and look at Article 22,
which is Article 20. Powers, is it?
yeah, 22 is at page 6517. So if you scroll down to page 6517,
6517. Yes.
and if you look at number 22, which is headed judicial review and injunctions,
The court of first instance may hear and determine applications for judicial review or substitution review.
I'm looking at page 6517,
Yes.
and
The
I'm
court of
looking at
first instance may order injunction restraining a person from engaging in any conduct or requiring a person to do an act or thing other order the courts considers appropriate.
yes,
I don't deny that.
yes,
But the jurisdiction, the area, territory of jurisdiction is not mentioned in 22(2). It doesn't speak any part of the world. We have to assume that it is to cover within the IFC only.
Well, on our submission, and indeed the findings of Latif and Jones, is that that's not the case. And the reason we say that is because there's no qualification given to this jurisdiction whatsoever. It's open-ended. It doesn't limit the jurisdiction anyway.
Mr. Bohr, I'm not sure that's... If you're very keen on showing us the heading for this section, which is jurisdiction. Yes. If you go back to page 6516.
Yes.
Article 19, jurisdiction.
Yes.
And jurisdiction, as we just discussed, 19(1)(d says basically it's got jurisdiction over cases where it's got jurisdiction.
Yes.
So that doesn't help. But when you get to 20, 21, and 22, those don't have they have different headings. And 22 is not concerned with jurisdiction so much as power.
In our submission, what the provisions under 20 and 21 do is provide instances, including instances of where 19(1)(d) apply. And it's correct that jurisdiction is the heading of 19, but if you look at 6516 chapter 1, so the heading above that in uppercase,
yes,
and indeed the two headings, they're both headed jurisdiction of the court of first instance. And so in our submission, what this court law is doing is setting out the gateways, which and that of course includes 1D, which is very broad indeed. And actually then dealing with instances where that jurisdiction can be exercised. And therefore, under 22, it deals with two things: judicial review and injunctions. And 22.2 deals with injunctions. And in our submissions, and as I say, the findings of Lateef and Jones, which we rely upon, is that 22.2 is very broad and unqualified.
Yeah, right.
And so that's one instance, we say, of where jurisdiction is given in very broad terms to the court to make orders, including in support of foreign proceedings. I also yesterday, since we're on this, drew your attention to clause Article 32, which
Not a jurisdiction section,
which is a powers section, absolutely. But what we would say in our submissions is the two should be read together. But Article 22 is certainly more helpful to us because as you correctly say, this does say power on it. Now, I also looked. We can look back at this. If you go back, we looked at Nest. I don't believe I need to take you to that, but I can do, because Nest was the Court of Appeal Authority, which tells us that the rules of court, the RDC rules of court, are DIFC regulations. In other words, if I can point to a rule of court which says that the court may make an interim order, then that would fall within the gateway, or that would provide a gateway under JL 1AE.
Well, you're jumping. You say it would put you within the gateway only
Yes.
if it was construed as giving jurisdiction as well as power.
Yes, I accept that.
Yeah.
Accept that, and I mean,
It seems to me that's the fundamental. I mean, I'm not saying you're wrong or you're right, but the fundamental question one has to determine about jurisdiction is when these various regulations and articles and so on are referred to us, to draw a distinction all the time in our minds, at least, as to whether they're dealing with jurisdiction or dealing with powers.
yes,
That's how I think it would at least be relevant in the discussion.
yes. Well, on that, Lord Glennie, I would submit that Article 22 gets us home. We do say that is giving the court jurisdiction, and I mean, there are other provisions as well which the court can rely on, and they certainly support the proposition that the court's powers are unlimited, because everything that I've shown the court, nothing at all qualifies that power. If you
look at 32, just while we're on this, I don't want to interrupt you too much.
No.
32 powers, you accepted that may not be your strongest section, but just looking at powers, 32, the DIFC court has power to make orders and give directions as to the conduct of proceedings before the DIFC court. So
yes.
You look at, so it's dealing with cases where the court has jurisdiction and has an action for it, and what are its powers in such a case. So it can't be used surely to help you found jurisdiction.
Well, as you say, it's not my strongest point. The only answer that I have to that is that because when you're applying for support of an interim injunction in support of foreign proceedings, you apply under Part 8, then the claim does come in front of the court, and then the court can then make these orders.
So it means the conduct of any proceedings, rightly or wrongly, before the DIFC court.
Well, yes. I mean, they'd be full report. But I mean, you'll have the point that Article 22 is our foundational article for these purposes,
which says that you have jurisdiction where you have jurisdiction.
Well, no. Well, the one that says that courts can, that's what 1A says, but then, as I say, 22 goes further than that.
Okay.
And this second point. And we can look back at next, and please tell me if you want me to do that or whether you're familiar with that case. But the Court of Appeal says, and it was looking at RDC Rule 20.7, but what it says in terms is that rules of court are DIFC regulations for the purposes of the gateway at 1AE. And so when we look at those court rules, and I mentioned them, but maybe let's go back to them. It's at 6562.
Which rule are you looking at? 20?
well, that's 25.1, where it says the court may grant the following interim remedies.
Yeah.
In our submission, that is a grant of power. I mean, it ties in with Article 22. It's not of the court law that we looked at. It's not necessarily. It's not freestanding, or doesn't need to be freestanding. But it's very clear in what it's saying. There's no suggestion that's limited anyway. And if you scroll down and you come to 25.4, again, and this is headed jurisdiction. So I'm looking at page 6564. A judge may make an order for an interim remedy.
So, sorry, just going back to 25.1 for a moment.
Yes.
It's sometimes useful to see other powers within the same section. Yeah. Look at 25.14.
Mm-hmm.
I think you say because the court is given the power to authorize a person to enter a land or building in the possession of the party of the proceedings, you could make an order. The court can make an order where there is a case between two parties in DIFC, but one of them owned a building in London. The court could make an order regulating entry into that building in London.
Well, it could authorize a person to enter that building into London, but of course, as
far exorbitant jurisdiction, wouldn't it?
Well, the point that Justice Jeremy Cook made in Jones, and indeed in this case, is these powers are extremely wide, but the exercise of them will put them into reasonable context. So, a court obviously would have no power in relation to a foreign building, but could in an appropriate circumstance make an order in relation to a person outside the jurisdiction. But there'd have to be other factors, and we'll come to what those are. But that the power nevertheless exists. Now, if the court says, well, that 25.1 doesn't get you home, then we do have 25.4 as well, which does just relate to interim remedies.
25.4.
Yes, which is at page 6564.
Yes, I see.
6564.
The word interim rather suggests that it's a remedy in the course of some other proceedings that exist, but maybe I'm wrong.
Well, no, that we would say that's right, but those other proceedings need not be within the DIFC, and there's nothing in this very short provision which suggests otherwise. And then if we finish with this, if we look at 25.24, which is the provision I was looking at earlier.
So there are two aspects of this, One is the power to do something, an act to do something.
Yes.
The other one is the territory, the place that you are empowered to carry out that. You're given the power to enter, as Judge Lord Glennie had just said just now.
Mm-hmm.
But can you order that act to be done in London? I mean, to stretch that to me is a bit of a stretch to go to that extent.
Yes. Would the court do that? No, the court wouldn't do that. But could it do that? It could order.
The question is, could it do that? That's great.
Yes.
Are you saying that they have that power to do so?
They have jurisdiction to do that, because that's the way that the DIFC works. It doesn't relate to jurisdiction through service, what's being called in personam jurisdiction. There are gateways, and there's an unqualified power or jurisdiction in relation, for our purposes, we need to show it's in relation to interim remedies and freezing injunctions. But if we're right about 25.1, that would extend to other other powers. As I say, we also have 25.4. So, even if the court says, well, 25.1 is really about power, 25.4 actually says jurisdiction at the top of the heading of that, which precedes that rule. So it's very hard to say that this provision here, a judge may make an order for any interim remedy. A 25.4 does not deal with jurisdiction. We say it does deal with jurisdiction. And then we have this curious...
Mr. Moore, if you allow me, jurisdiction itself can mean power, isn't it? So, is that right?
It can, and this is part of the confusion, and the judge explained this in his judgment, because jurisdiction is sometimes used as power and can even be conflated with the proper exercise of discretion. And my learned friend, we would submit, certainly uses it in that way when he says that what's not right to, there's no jurisdiction because the order, there's not enough of a connecting factor and these kind of things. But jurisdiction itself simply means, does the court have an original right to make an order in relation to something? Now, there was a phrase yesterday in one of the cases, I think it was a PwC case, where we talked about unlimited jurisdiction, and my learned friend talks about common law courts having unlimited jurisdiction. And what that means is that they would say that they are the supreme power, and they can make whatever order they want. Apart perhaps from, as I gave an example of deciding the status of someone in a foreign jurisdiction, they wouldn't say their powers was unlimited in that respect. But other than that, in theory, they can make any order. Would they do so? The answer to that would be no, they wouldn't. They would have to apply well-trodden principles and well-established principles. But nevertheless, common law courts see themselves as courts of unlimited jurisdiction. And what that means is, the effect of that is that if orders are made, even if they are improper, they need to be obeyed. That's the effect of that. Now, my learned friend says, well, that he accepts that applies. The unlimited jurisdiction applies to common law courts, but he says it doesn't apply to the JFC court, because the JFC court's jurisdiction is statutory. It's not based on common law, which is correct. And my submission, and indeed the effect and the findings within Latif and Jones, is that regardless of the fact that this court's power is statutory, it gets you to the same place in the sense that the powers given, particularly in relation to interim injunctions, are unlimited. They're unqualified, and they're only qualified when it comes to the exercise of those powers. And that's a separate stage. That's the exercise. That's a matter of discretion. And of course, it can't be exercised capriciously. It has to be exercised within certain parameters, and I'll come on to discuss those. But in terms of the actual power, we say it is unlimited. And the provisions.
What's your answer if you see in 25.4 itself? Or 25.5, then the rule says the power of the registrar. The heading is jurisdiction.
Yes.
Then the judge may make order, and then it talks about the power of the registrar to make such things.
Yes.
But I mean, if you combine these two words, jurisdiction at the title, and then power,
yes,
the subtitle, what would that mean?
Well, I think the way to read this is this provision deals with jurisdiction, as it says in the heading. 25.4 sets out that jurisdiction in very clear terms. It's unqualified, which would be the same as in the English court. And 25.5 then moves slightly to explain that jurisdiction can be exercised by the registrar, in accordance with the rules.
Yeah, that jurisdiction has a power, isn't it?
Yes,
25.5.
25, I accept that, Your Excellency. 25.5 deals with the powers of the registrar, but certainly 25.4 deals with the main theme of this section, which is jurisdiction.
Which is the territorial lines of the court.
Say this again. Sorry?
You mean jurisdiction? Again, it's not as a power, but as a territorial line.
Yes.
I see.
Yes. And then I also discussed 25.24. And to be clear, I'm not saying that 25.24, I'll just take you to it first. It's on page 6568. So 25.24 says where a party wishes to apply for an interim remedy, but the remedy is sought in relation to proceedings which are taking place or will take place, so in the future, outside the DFC. And then it says this application needs to be made under Part 8. I'm not saying that this gives the court jurisdiction. I'm relying on Article 22 of the court law and 25.1, 25.4 of the RDC rules. But what I am saying is this does provide support for the proposition that a court can make an order in support of foreign proceedings, even though the other gateways, even though there are no other gateways that apply other than 1A E. And that was a comment that was made in the Jones case, which I took you to. And it was an argument made by Mr. Montague Smith. And the point I was making just earlier is that the argument is a good argument. It's a good argument because this is clearly dealing with a situation where these substantive proceedings are not in the DIFC. And because there's no substantive proceedings in the DIFC court would not have any jurisdiction over any party to those proceedings, except under Article 1AE, the power to make interim injunctions. And so therefore it must follow, we say, and indeed as the court found in the Jones case, it must be that the court does have power to make orders in support of foreign proceedings, even where the other gateways, in other words, A to D, do not apply. Is that last point clear? Because it's quite a subtle point, and I have to confess it took me overnight to think about it. But that's the way I read it, and it makes sense in the context of the wording of the JAL and the court law, Article 19, because jurisdiction is only given where there is a claim before the DIFC. If there's no claim, there's no jurisdiction, and therefore the only way of making an application in support of foreign proceedings would be through Gateway 1AE.
My last question for you, Mr. Bor. How may a person in any part of the world, in Brazil, in China, in Australia, and England, would protect himself from being subject of any order from the DFC court? It's in a country he's never been there, never done any business there.
Yes.
With this wide powers, I mean.
Yes. The answer to that is very simple. There's two answers. Number one,
he has to come here and defend himself.
Well, there's 2 points. Number one is, if in fact I showed up in the DIFC court and asked for an order against a Brazilian party, when there was no connection to the DIFC in any respect, in other words, in relation, the assets were all in Brazil, nowhere, not even close to the DIFC, that there was a simple contractual dispute in Brazil, and then the court would tell me that they're not going to make that order. So that we would submit that wouldn't happen. But if for some reason my advocacy skills extended to persuading the court that they should make an order in such a circumstance, then that person would have to then appear before the court and say there's no jurisdiction, and they would get their costs of having done that. But what they wouldn't be entitled to do, and I'll show the court authority to this effect, they wouldn't be entitled to just ignore that order, even if it was inappropriately made. So there were, as I say, in answer to your question, there were really two protections. One is that the court would not make an order because there'd be no basis, there'd be no preliminary jurisdiction to make that order because the court would find it didn't have jurisdiction. But if it did, the other party would have to defend it, but it'd be very easy for them to do so. The other point I would make is the question you're asking me applies not just to the DIFC, it applies to all common law courts. And the obvious example is the English court, which has unlimited, and that's the word that's used in the cases, unlimited jurisdiction. If indeed a court made, for example, in that PwC case, a winding up order in relation to a company, that company can't ignore it, even if the court didn't have jurisdiction in the broader sense. Because the court has unlimited jurisdiction, that party has to get back in front of the court sharpish and say you don't have jurisdiction.
I might disagree with
Yeah,
I might disagree with you, Mr. Bor, here, because the English court, at least, or many other jurisdictions, would not allow you to serve the claim form first of all without convincing the court there are a link with this court, or there is a decent purpose. Why would you bring that case in here?
Yes, that's a very good point, and that is the same point that I would be making in relation to DFC. Although the DFC doesn't have service out as a criteria, it would still consider whether or not such an order would be appropriate, given the circumstances. And so, as I say, in a circumstance where there was really no connection or anything to do or any kind of fraud or any real need for an order to be made, the court simply wouldn't make it. And so in my submissions, the DIFC court, if the court finds in our favor, would be in no different position to the English court. The English court has unlimited jurisdiction. This court would have what we've been calling unqualified jurisdiction in relation to interim orders.
But the English wouldn't trouble people to travel to London, defend themselves, because the judge would do the checklist for them. So the system would protect the outsider from being served without unnecessary or undesirable claim form. So the court would do the work first of all. Well, in this hypothetical case, with the DFC, you would like to trouble everyone on this earth to come and defend themselves before a judge in the DFC, which is we have nothing to do with.
In our submission, that the DFC court would do exactly as in England, would do the same work. The only difference is the DFC court wouldn't look at the question of service, but would still have to look in the question of a proper exercise of its discretion.
So if you
would
concede,
still have to consider that.
If you concede just now in your submission that the DIFC court will throw and strike out that action on the basis that it doesn't have any jurisdiction in the first instance, why do you want to file before the court? Why does the parties fighting in Brazil want to choose to file in the IFC, knowing that it's going to be thrown out anyway?
Well, they shouldn't. I mean, that's the answer to the question.
That's what we are saying. Your client as well. Your client shouldn't file before the DIFC because your dispute is in England, in US, in Cayman Islands, in Kuwait, but not in the IFC. The only thing you have in the IFC is your speculation that they have assets in the IFC. That's the only thing that connects you to the IFC.
Chief Justice, there's a number of points that arise out of that. Firstly, this is a different situation. Maybe the way to answer all those points is to take you through the process and thinking. And because there's a number of points there which we can't accept. We came to the DIFC because there's not speculative assets within the speculation relates to assets in the DIFC. Let's put that aside. We're not arguing there are assets in the DIFC. Our link to the jurisdiction is that there are assets and there was evidence for assets in Dubai, onshore Dubai. That's not the DIFC. We accept that. And I took you yesterday to the witness statement, which lists all the connections to Dubai, and there are a lot of them. We also submit, you asked me this morning about the conduit jurisdiction, and the DMB case is authority for the proposition that it is right to use this court as a conduit to Dubai. If you look at 1033,
again, I beg your pardon, Abi. What was it again? Sorry.
1033.
That is page 1033, is it?
Yes.
1033. Okay, sorry. Okay.
And if you look at paragraph 129,
What case is this?
this is it's head, you can see DNB and Gulf Ayada case.
Right.
DNB, then I guess, okay.
Yes.
Yeah.
And this is an enforcement case which went to the Court of Appeal in 2015, and it's one of the cases which people refer to in relation to conduit jurisdiction. And paragraph 129 really expresses the principle which the DIFC court has applied time and time again. And that is, from the perspective of the DIFC courts, it is not wrong to use the DIFC courts as a conduit jurisdiction to enforce a foreign judgment and then use reciprocal mechanisms to execute against assets in another jurisdiction. The DIFC courts are not concerned with what happens in the Dubai courts, in which the claimant seeks to enforce its judgment, as it does not have the jurisdiction to dictate what they should do. However, the holder of DIFC court's judgment recognizing a foreign judgment will seek enforcement of the DIFC court's judgment at its own risk.
Yeah,
and
it's enforcement of judgment.
Yeah.
Enforcement. Yeah, that's what I asked you yesterday.
I need to take
The same thing I put. You're going enforce of judgment is a different
Yeah.
thing altogether.
Absolutely.
You obtain a judgment elsewhere, you enforce here, but
Correct.
you're not asking for enforce of judgment in this particular instance.
Correct. So we need to take this in stages. So stage number one is that this court, the DIFC court, has a conduit with the Dubai courts. It has this, what I'm going to call this special relationship.
So you're extending this. Now you're extending this conduit jurisdiction to not merely enforcement, but filing an action. If you go to the JL, the JL will say you go to the Dubai courts to do that.
Mr. Bohr, I'm very familiar with this case because it was against my first instance decision.
Yes.
They were a judgment, international judgment.
Oh, that's right. I was before.
Come for enforcement, relying on Article 7 of the JAL, which giving a direct connection, but the enforcement assets were not in the DIFC. And I remember I've rejected that. I said, I'm not going to enforce away from the DIFC. That is my limitation. I have no hand outside. The Court of Appeal decided no. Then they use this what called the conduit jurisdiction.
Mm-hmm.
But there is a proceeding abroad. Our decision in the aid of that international common law jurisdiction judgment. And yeah, from that basis. So, but the link was Article 7.
Yes. Okay. So let me. These questions are pertinent and very, very important. So let me answer them. And Your Excellency, I was actually in front of you in the court of first instance, but I do have some recollection, although I've forgot a lot of the case. But this is the way I'm going to put it. Point number one. The DIFC court there is a conduit jurisdiction which has been recognised by the Court of Appeal. It is correct, as the Chief Justice says, it's about enforcement. But what we saw yesterday was the proposition in broad idea, the Privy Council case, that actually freezing injunctions are also about enforcement. But they're not about enforcement of judgments that are in your hand already. The purpose of a freezing injunction is to make sure that when you get judgment, you can enforce against assets. And so our reasoning is that there are assets in Dubai, not speculative assets. We have identified assets in Dubai, and there has been no challenge that those assets existed or exist. We say that the DIFC court has power to enforce a judgment of Kuwait and France. And therefore, it is possible for us to come to the DIFC court, to turn those judgments into DIFC judgments, and then enforce against the assets in Dubai that have been frozen. The DIFC court is very well placed to, number one, make freezing injunctions because it's based on, it follows the international procedure and English procedure in relation to that. It knows exactly how freezing injunctions work. And because it is an international commercial court, it understands commercial cases and fraud cases. So that's why we approach the DIFC court. More than that, this is not a case where there is just one obvious jurisdiction. As the Chief Justice identified, there are proceedings in Kuwait and there are proceedings in France. Those are the proceedings we rely upon. It is true, there are also issues in the Cayman and the US, and there are assets that have been identified in the US and the UK and in France, as well as Dubai. In other words, there is no one court which is the best place to deal with all these assets all over the world, all these cases all over the world. The DAFC court is, we would say, perfectly placed to deal with that because, firstly, the parties are in Kuwait, which is, of course, a Middle Eastern country.
The parties in Kuwait?
Yes.
Parties are not in Kuwait.
Yes, yes, I think they are in Kuwait, or they have been. I mean, they move around a lot, which is another point. But they are, I believe, in Kuwait, and of course there is the GCC treaty and the Riyadh treaty, and of which the UAE is a party, as is Kuwait, and we have, of course, this Dubai jurisdiction. So just to summarize, there's the conduit jurisdiction point, which connects it to the DIFC. We have the international aspect of it, both in terms of where the assets are, they're all over the world, plus the cases are in different jurisdictions, plus the parties themselves move around a lot. We can see them traveling around the world. It is also a fraud case, which puts matters in a different category. If I can take you very briefly to page 6698. So this is a case. Please do tell me when you have the page.
Yes, I got it.
Yeah. So this case of ESSA, ArcelorMittal versus ESSA, deals with injunctions. If you look at 73, what the English court says in relation to fraud cases. So there was no dispute that this is a good summary. So this is talking about the summary, going through many of the principles that my learned friend dealt with yesterday about when a court would make injunctions in support of foreign proceedings. There are, however, a number of matters that I consider to be important in that context. First, as it is clear from paragraph 44 of the judgment, Papa LJ was not considering a case of international fraud. Secondly, it's clear from cases such as Republic of Haiti that cases of international fraud, the English court may be more willing to intervene. And then it continues. I won't read the whole paragraph, but you can read it yourselves. And then it also says that this is not a case where Section 25 of the Civil Jurisdiction and Judgments Act is directly applicable. And that act, as was pointed out yesterday, deals specifically with applications in support of foreign proceedings. We don't have that act or the limitations of that act in this jurisdiction. And so the point I would make here is that when a court is dealing with fraud, it will be more willing to make injunctions. In the case of Brazil, which His Excellency gave me earlier as a test case, you know, if it's a straightforward commercial claim then of a Brazilian and there's no assets anywhere near the DFC or in Dubai, then the connections would be remote and the court would say no, you know, no at the preliminary stage. But here we say that the judge, faced with a conduit case, a case of fraud, and we looked at the French proceedings and we saw the word fraud being used, an international case, then the court is entitled to make the order. And again, we should remind ourselves, and I took the court to this yesterday at 1196.
But Mr. Bohr,
Yes.
you would agree with me that allegation of fraud is very serious. And the court is not going to accept simple allegation of fraud as proof of fraud. They would want something stronger than that. And the fact that the French court rejected your application shows that your case is not that strong as far as allegation of fraud goes.
Right. So there's 2 points in relation to that. First, well, 3 points actually. Firstly, it's quite right that one can't just simply allege fraud. The French claim was that we have to look at the situation when this matter came before Mr. Justice Cook. The French claim was not dismissed, and indeed, the actual claim itself is not dismissed now. The only reason I'm told and understand is that the claim has not gone forward is because there are issues about jurisdiction of the French courts in relation to the criminality. But in fact, the prosecutor, and this has been pointed out by Mr. Pierre Olivier, who's a lawyer in France, the French prosecutor itself has said that the claim shows criminality, but the concern is that the court may not have jurisdiction, and the finding in relation to jurisdiction is being appealed, but nevertheless in relation to that, but nevertheless there is a civil claim in France on foot as we speak. So that's the first point. The second point is the standard that we need to prove. We only need to prove that the claim is not frivolous. We don't need to prove or establish fraud, that there is actual fraud. That's what a good arguable case means. And we can do that because if one stands back, what we have here is a company that at one point was worth $180 million and is now not worth anything. And there has been no explanation given that I've seen, at least in front of this court, and I haven't seen any evidence, to be honest, to explain where all these monies have gone to. And that in itself suggests that, you know, if these monies have gone and they've been taken unlawfully, that there's some kind of very serious wrongdoing going on here. So we would submit that we have amply met the preliminary or the test of approving a good arguable case. And indeed, I don't believe my learned friend is saying we haven't met the good arguable case. It's what it really says is the proceedings aren't the same proceedings. And the other point is my learned friend cannot say there is no good arguable case, because if we go to page, and we'll see that if you go to page 7014.
You took us to 1196 for some reason, and you haven't referred to it.
Thank you. It's before we move off that 1196, paragraph 41, was simply the proposition that I mentioned yesterday, that what the court, and this is the gateway issue, the protection issue, that what the court needs to be satisfied is that there is preliminary jurisdiction. Now, we would say we've got a much stronger case than preliminary jurisdiction, but at the very least, I'm looking at paragraph 41, at the very least, the judge was right to make the order. It was in his jurisdiction, certainly, for the reasons I've said, and in his power. In other words, he was doing his job as a gatekeeper, to use His Excellency Madhani's words. He was doing his job as a gatekeeper very well. And you know, especially when he only needed to decide on a preliminary basis. What should have happened, of course, is that the other side should have come along and contested anything they want to contest. And for that, I'm going to take you to 7014. That's the page I was going to take you. Do you have this page?
Again, sorry.
Oh, yeah.
7014.
Is G on injunctions?
That's right, yes. So G on injunctions, very well recognized book. My learned friend puts in citations from this textbook as well. And he summarizes the principle very clearly at 24005. Where there is an interim order made after a hearing on the merits inter partes, the court will not entertain an application to set aside that order, a part of it, which is inconsistent with that order, unless there has been a material change of circumstances or some relevant misrepresentation or mistake which makes it just to do so. And it goes on to explain that the principle avoids re-litigation of the same application. it applies when it's open to the applicant. It applies when it is open to the applicant to take the same points of the original hearing, even though he did not do so. And then it goes on in the second paragraph, the principle of abuse of process applies both to interlocutory hearings and to final hearings. And the point here is that the judge, we say, was completely correct to allow the order to be made, to make the order based on those factors that I mentioned. There's a link to DIFC through the conduit link, because there will be possibly an order, a judgment enforceable through the DIFC against the assets which are frozen by the DIFC. It's an international case. There's no one court which trumps the other courts. It is also a case of fraud, proven at least the good arguable standard, which is the right standard. And we have in this case the additional factor that the parties did absolutely nothing to challenge the orders of the court for 9 months. They didn't come in front of the court. They didn't appeal the order.
I think you've made that point on a few occasions, but
it's hard not to keep repeating it, because actually it distinguishes this case from any other.
Yourself, we seem to move from a point I wanted to ask you about some time ago.
Yes.
And it's in the context of the DMB case, which was at 1033, I think, and the question of conduit jurisdiction. I just want to be clear about this, because I wasn't in that case, and I just want to be clear as to your submissions on it. Are you saying this is a case of conduit jurisdiction?
What I'm saying is this is a case of conduit jurisdiction, in the sense that what we envisage is that there will be a judgment from a court, possibly Kuwait, that will be enforceable through the DIFC court and recognizable by the DIFC court, either through treaty or through its own other statutes. And then that will be able to be transported through the conduit to Dubai, which has this special relationship.
There is at present no foreign judgment that you seek to enforce by conduit jurisdiction.
No, there isn't, and so the missing piece of the jigsaw is the enforcement principle.
I'm going to find out an answer to my question. You've got to allow me to ask the question first.
I'm sorry, Lord Glennie.
Am I right in thinking that conduit jurisdiction works in this way, that at least the DMB model, that you have a foreign order, for example, for a worldwide Mariva injunction issued in London, and that is then accepted or made an order of the DIFC court for enforcement purposes, and then the DIFC court order can then be enforced in Dubai, for example. Is that right?
Yes, but it's not just for freeze injunction. It'd be judgments, of course, as well, or arbitration awards. But yes, that's correct.
But in this context of freezing, you normally get an order enforcing the foreign judgment, the foreign order, in the same terms as the foreign order.
Yes, but in the relevance in our case, we would say, is in relation to the ultimate judgment on the cause of action in Kuwait or France.
So this is a anticipatory conduit jurisdiction.
That's correct.
That's an anticipatory conduit jurisdiction.
Has there been a case of anticipatory conduit jurisdiction established in these courts? Or are you going to point me to Jones and Jones and
that's what I'm Latif. I'm pointing you to Jones and Jones primarily, but I'm also going to point you to the broad idea case that I took you to yesterday, because
before you come to that, and I take the point from broad idea, we'll take your point from it, but neither Jones and Jones nor Latif base themselves on the notion of conduit jurisdiction. Is that right?
I think they both mention it. Certainly Latif does, because I recall taking you to that yesterday.
I don't think they found their decision on it.
Because the reason they didn't found their decision on it is quite important for our purposes, because they were considering this question of foundational, essential jurisdiction. And so they found that they had essential jurisdiction, but they also noted that there was this conduit jurisdiction. They were dealing with Dubai cases as well. And I dare say that if they weren't to make good my point, I dare say that if they weren't dealing with cases where there are assets in Dubai, the outcome may have been different in relation to the exercise of their discretion. They may have said, yes, we have jurisdiction, but there's not enough of a connection. And so I do say that the conduit jurisdiction was relevant to those cases because they recognized that orders can be easily enforced between these two jurisdictions.
Okay, the basis on which conduit jurisdiction is permissible, and forgive me if it's covered by DNB and the other judges know all about it. The basis on which it is permissible is on the basis of Article 7 of the JAL, is it?
I believe so, yes. I think there's Article 24 as well, if I remember that. Oh no, I think that's the RDC rules. So yes, I think that's correct. Yes.
Right.
Yeah.
So, but Article 7 of the JAL requires there to be an actual judgment abroad to be enforced.
That's right, and the Chief Justice's language of anticipatory is correct. We are saying that the conduit always exists, whether we're employing it or not, but we rely on it because what we say is, and tell me if I'm going off piste in relation to the answer to your question, because I'm going to mention broad idea now, but the enforcement principle is that you're looking at prospective judgments. That's the purpose of the injunction, to protect assets pending a future judgment. And what we're saying is, when we get this judgment in the future, then we're going to enforce it through the IFC against the assets in Dubai which have been frozen. And indeed, globally, the connection to the DIFC is through the assets in Dubai.
Apart from what you said, Jones and Latif, and put them to one side for the moment, has there been any case in which an order has been granted on the basis of conduit jurisdiction in anticipation of a foreign order?
Not that I'm aware of.
Thank you.
In the DIFC, but of course, the principle that you get your freezing assets in anticipation of future judgments, of course, is common.
I think the DIFC powers and jurisdiction.
Yeah.
Okay,
yes.
that's helpful. Thank you very much.
Yes, and so again, just to kind of bring this all back, because I know we've covered so much ground. My primary point is this court only needs to, for justice to succeed on the first ground of appeal, which is jurisdiction, the court only needs to look at essential jurisdiction. And what we say about that is the court in principle has unlimited or unqualified jurisdiction, just like the English courts. That does not mean, again, just to be clear, that does not mean that the Dubai courts, the IFC courts, will make orders in every situation. It will not. It will still consider issues of expediency. It will consider the cases that my learned friend took you to yesterday, ICC versus Dominici, but it will take note of the fact that that applies to Section 25 and deals with service. But it'll take those principles and apply them accordingly. It'll also have regard to cases like the Mittal and Essa case that I looked at, and that will be the gateway. That's why this court won't make an order against an individual in Brazil suing another person in Brazil under a contract. It won't make that order because it won't pass that threshold. But if it's some further connection, it will make that order, and then the onus is on the party served then to come before the court, applying the principles under 24005 in G. And that is, and we would submit further, that is exactly the same process that applies in England and in other jurisdictions. And it's workable, number one. And number two, it serves parties who are trying to preserve assets in cases where these assets are being dissipated around the world. And so to us to succeed on the ground one, the court simply needs to find that there is unqualified jurisdiction. In other words, it can, in principle, make orders in support of foreign proceedings, even though there are no assets directly in the DAFC or parties in the DAFC.
Yes,
and that's it.
So, sorry, I'm just worried that the Deputy Chief Justice's screen is frozen. Whether he's still with us or not, I'm not sure.
Oh yes.
Yeah, Charlie, are you there? Okay.
I'm there. I don't know. Do you hear me?
Okay.
Yes, I hear you. Yeah.
Okay.
We can't see you frozen, but we can hear you loud and clear. So again, essential jurisdiction is what we need to win on, and we say we've shown that through Article 22 of the court law and the rules in the RDC, and 2524 supports us. But in addition to that, you've asked me quite rightly about why we came to the DIFC, and I've explained why. An international case, a fraud case, established the requisite level, unchallenged evidence in relation to where the assets are, and unchallenged WFO. And therefore, the court was right to make that order. And therefore, but however, I'm going to go on to say, and this is what I'm going to go on to next, is to say that actually the court was also right not to want to hear arguments about it. So unless there's any further questions on jurisdiction, I'm going to propose to move to my second point, which is discretion. Should I continue then?
Yeah, please.
Yeah. So ground one, discretion. Jurisdiction. Ground two is discretion. And yesterday I took you to the Motorola case, and I wasn't proposing to take you back to it, but please do tell me if you need me to. But there are really three different areas, or 3 points that I take from that case. So the first point, taken from paragraphs 47 to 52 of the Motorola and Uzan case, which is at E24, is that the court has discretion not to hear from someone in contempt. And the question for the judge in each case is the interest of justice. Is it in the interest of justice to allow this person who's in contempt to make submissions? There, the second point comes from paragraph 52 of that case, which is a citation from Lord Oliver, where he says that a court would be unlikely to exercise discretion where there is an abuse of process, number one, or where there is where the disobedience impedes the course of justice, number two. And the reason why that's important is because, as I've shown you from the G citation at 7014, there is an abuse here in the sense that the parties the defendant parties did not appear or challenge the order in time or appeal the order or anything of that sort. And number two, we say there is an impeding of justice because the purpose of a freezing injunction and the information, the affidavit that's required to be provided, is so that we know exactly what assets there are and whether they're being dissipated. And that goes to the justice and also because it goes to whether or not we're going to be able to enforce ultimately. And we have been impeded by the contempt because we don't have that information. And then the third principle that I take from the Motorola case comes from paragraphs 148 to 151, which is that a party, even if an order should not have been made. So again, this goes to the discretion point. Even if the discretion should not have been exercised, then a party must still abide by that order. And if they don't, then they are in contempt. And I know my learned friend took you to it, but I'm going to take you to this too. But just on that point, if we look back at the PwC case, which is at 1309, so again, just to remind ourselves, this was a case where a BVI Supreme Court made a winding up order, which it had no jurisdiction to make. And then it came before the Privy Council because that order was not obeyed, but it was wrongly made. And this is what the Privy Council said at paragraph 25, 1309. So far as step one in the respondent's argument is concerned, it is well founded. The board accepts that even though the Supreme Court did not, in fact, have jurisdiction to wind up this company, the order it made to wind it up and to appoint an official liquidator, at least until it's set aside by a subsequent order, must be treated as effective in law. And this is because of the short and well-established ground that an order made by a court of unlimited jurisdiction must be obeyed unless and until it has been set aside. And so this fits in very nicely with the distinction that I've been making throughout. The court of the BVI, like the English court, has unlimited jurisdiction. Yes, it has jurisdiction even over a party in Brazil, if service out is granted, but and therefore it must be obeyed, even though it doesn't have jurisdiction in the sense of power or discretion to make a particular order. And that's the principle. And this, we would submit, as a matter of policy, makes law workable, because parties are not free to do, as Mr. Liebiter says, consider that an order is not binding on them and just sit back. They're not free to do that under these principles. And it's not just
Mr. Bob.
Yes.
Can you assist me by why did the court rule that there was no jurisdiction to do to make that winding up order? What was it? Does it go to jurisdiction of the court as jurisdiction, or does it go because the wording of the winding up order or law relating to winding up order does not extend to this particular party?
I believe, as Mr. Liebiter said yesterday, that it's because the company was not based there, it was not registered there, and they didn't have jurisdiction over that company.
Okay,
they had essential jurisdiction over that company because it was they have unlimited jurisdiction, but they didn't have the power to make that order in that sense. And it's that distinction. So provided the court has this essential jurisdiction, which it would always have, pretty much, or mostly, then the order would bind. And now and this principle, again, I took you to G already, but we can see how this principle features in the commentaries. If you go to page 7016. Do you have that page?
Yeah.
You'll see there's a highlighted section here, just 2 lines. So this is from G. An injunction takes effect at the moment it's pronounced, unless the court orders that it's to take effect from a later date. It continues in effect unless and until it is set aside. Breach of the order is a contempt, even if subsequently it is set aside. It's that same principle. And then if we go to page 7043, this deals with irregular or unjustified orders. So this would apply even if this court felt that the judge had not exercised his discretion in allowing the order at the outset, which we say it should not do because we say he did exercise his discretion properly. But even if it is the case, this is what G says. No one can justify contempt on the grounds that the order should never have been made or was irregular. If an order has been made, it must be obeyed until it is set aside. Whether the original order should have been made may be irrelevant to an appeal challenging a committal order made on breach of the order. So it's not a relevant factor.
Mr. Bohr, just so I'm clear on this, I think I am, because I think you explained it yesterday. This is not concerned, this section of your submissions is not concerned with what we sometimes call essential jurisdiction. Is concerned with if there was in essence power to make or not to make an order. It goes to a case where the defendant would want to say shouldn't have made an order.
That's right. It covers everything except essential jurisdiction. Yeah. In other words, even if the order is set aside at what this is saying is if a party comes along later, and let's assume that the party comes back at the return date in time and says that the order I've not complied with the order because it should never have been made, and because there was no good arguable case in relation to fraud, for example, the court would say okay, I'm going to set aside the order in that situation if the court agrees with that party, but it doesn't matter. You're still in breach because there was essential jurisdiction, and we have this principle here, and I've shown you some case law that it needs to be obeyed. You're still in contempt of the order. Now, our situation is completely different to that, because our situation is, it's not only that the party came back, it's not that the party came back. I won't repeat myself because I know you told me not to repeat it too many times, but you know exactly what I'm going to say. The party didn't come back at all. And more than that, as I've shown, the judge was well within his discretion to make the injunction in the first place. There is no good reason to set it aside at all. There never was. So, I mean, that's what I'm taking from G. With your permission, I want to go and look at how the judge dealt with his discretion, which one finds at 1623 in the transcripts. So if you put the page 1623 in, it'll take us to the transcript.
We had problem tracing the Jeremy's judgment because he didn't appear as a separate judgment, but as part of the transcript.
Yeah.
I think Glennie for pointing that out to us. Okay, page, what was it? Yeah.
Actually, I may need to take you back a little bit because I think it's
1623. Okay.
Sorry to disturb, but I believe Deputy Chief Justice is out of the call.
Should I hang on or wait?
Yes, I'm just looking into it now.
Thank you. While waiting, I actually, the page should be slightly before the one I said, so it's actually page 1611.
Chief Justice and
Yes.
Lordship Angus, the IT team is saying I think we should break for 5 minutes. Deputy Chief Justice has.
Let's take more than that. Let's take 20 minutes, half an hour break. Okay, that's all right. Half an hour break. Is that all right with everybody? Good.
Yep.
Thank you very much.
Good afternoon, everyone. I hope you hear me.
You okay now?
I apologize for what happened. My screen frozen completely, and I couldn't do anything about it. And I had to restart my computer again. But by then, you already are in a break.
Look as if you are working from the office.
Yeah, I'm in the office.
So why should that happen? If you're working from home, I could understand. Then I would say switch homes.
Oh, no, something wrong with the computer itself, actually.
I see. Okay.
But I'm fine now. I managed to handle it. Yep.
Thank you very much. So, yes, can you continue, Mr. Bo?
Yes, just one point before I continue where I was up to. You were asking about fraud. If you can go to document 6111, I'd be grateful.
6111. 6111.
Yes.
Okay.
You have that?
I should have it, but it's not coming through. I don't know. Yeah, 6111.
Yeah, it's a letter from Olivier Savoie Arbitration, the law firm for my clients in France, who's writing to the examining magistrates. You can see on the 6th of February. And this is following on from the decision not to continue the criminal prosecution. So this is the switch from the criminal to the civil. And what you can see from this, if you go to the page 611 itself, It starts at the top. As for the letter from the deputy, it's important to note, first of all, that it concludes that the alleged facts are facts that could be classified as criminal. The complaint is therefore serious and in principle must be investigated. So this is the French laws explaining why the criminal investigation should continue. But he's referring to a comment made by the deputy public prosecutor in France, explaining that the alleged facts could be classified as criminal. And then you can see from the next paragraph, the reason why the investigation was stopped and is subject to this challenge is it had to do with jurisdiction only, whether any acts took place within the jurisdiction. And then the third paragraph again refers to the kind of contradictions within the evidence, and showing how murky this all is. And so the point that I'm making, and I've made it continuously, that we're not banding around allegations of fraud baselessly. There is ample evidence of fraud, and in any event, none of this was challenged before the court. I'm just going to give you a few references, but not take you to them. But at page 6037, there's an updated statement from counsel in Kuwait about a criminal complaint.
Mr. Bor, if you allow me, this document does not talk about a fraud. It's about money laundering, isn't it?
It's criminality.
Criminality of money laundering, that an issue between a person and the system and the state, for example. It's nothing to do with your claim.
Well, the actual French claim itself, which is
you might have detected the action, you might report it to the authority, but that nothing to do. Money laundering is not. You're not the subject of the crime.
No, you're right about money laundering, but at 4378 is the French claim, which mentions not just money laundering, but 4378.
4378. Yes.
So it hasn't come up on my screen, but I'm just going from memory. But it does refer to other actually. Yes, if you scroll down, the second paragraph on 4379, the complaint for fraud is fraud in an organized gang, forgery, use of forgeries, misuse of corporate assets, and money laundering. So it's not just money laundering, and as has been explained by Mr. Olivier Savoy, this claim has both a criminal and a civil aspect to it. I mean, it's essentially being alleged that there's been a fraud, and as I say, that conclusion is quite reasonable. You have a company worth 180 million, and then is worth zero without any proper explanation as to where all the assets have gone. But I will take the court to some more documents later. But for the moment, I'm just going to give you one reference, one or two references. At page 6037, there is an update in relation to a criminal complaint in Kuwait. And there's an earlier, the actual indictment or the accusation report is found at page 5457. But I'm going to leave this subject for now and go back to the issue of discretion. And what I was about to take you to is the transcript. And if you look at page 1611, this is the place in the transcript where the decision starts in relation to the exercise of discretion under the Uzan principles.
Reference again, Mr. Bor, sorry.
Yes, it's page 1611.
Thank you.
So you were taken to this yesterday and you were shown some of it, but I just want to highlight some further points which weren't, I don't believe, highlighted yesterday. So this is the consideration that Mr. Justice Court gave to the question of whether or not he should allow the defendants to take any point they wanted, or whether he should limit those submissions. So he said the first question that this court has to decide is whether the defendant's application for discharge of the worldwide freezing order can be heard at all. And then he explains that the circumstances that the period of about 9 months has passed without where the defendants just ignored the proceedings. Then he explains what the position is today, which you were taken to. And the next paragraph, the court granted ex parte worldwide freezing injunction And then at page 1612, he makes the point that despite the fact that the defendants had instructed lawyers in Kuwait and the USA, with whom on the evidence it appears they were in contact, the only reason for giving for not appearing to contest the grant of the freezing injunction is to be found in the second defendant's first affidavit. And then he cites that. And so that is a material fact. This is not a situation. Sometimes an individual will be served with an order and not understand the meaning of that order, and therefore not comply with it. I mean, that's not excusable, but it's understandable. But this, and I'm going to use my learned friend's expression, is unpalatable. These are individuals who do nothing and have no reason for that. The judge also notes then at the foot of this page that the excuses don't constitute any good reason, and that by failing to disclose assets and then continuing to enjoy what appears to the court to be a luxurious lifestyle with substantial expenditure on travel. So it's the flaunting of the wealth in breach of the order that is troubling to the court, and that's understandable. My learned friend says they do not believe this order is binding on them. Then at the next page, he references the Uzan case, and the judge is very careful. He read this case very carefully. He cites passages and the cases that are cited in the case, and then he talks about the tension, because there's a tension because on one hand, on one reading of some of the authorities, when a party is in an abusive situation, and justice is being hampered, he shouldn't hear anything. On the other hand, he's told to look for the interest of justice. And what the judge does is he's generous. He goes for the interest of justice, and he says that the defendants can be heard on jurisdiction. And his reasoning, you can see at the foot of 1614, he goes to the paragraph 150 of Motorola. And you will recall that I took you to paragraphs 148 to 150, which deal with this point that even if an order is not properly made, provided the court had original essential jurisdiction, it would still be a contempt. And that's what's live in the judge's mind. And then he refers to other authorities, which I took him to, which really say the same thing as G says, that is, parties need to apply when they've been served with an order.
Is that PwC?
Say again?
Is that PwC case?
Yeah, but the case I took the judge, that's the case I took you to this morning. But there's a case of Paratus, and that made the point that the proper course for any defendant to take in circumstances such as these is to comply with the order and apply for a variation, which really goes to the question that you asked earlier, Your Excellency. What does someone do if they don't think that an order's been properly made? That's what they need to do. And then the judge
where do I get Paratus? Where can I access Paratus? Can you help me, please?
Yes, it's in the bundle. I think it's the M bundle.
No, just give me the page Paratus.
Yes, I'm going to have to. These are added somewhat late, so I don't actually have the reference to hand.
Okay.
But I can get you that reference. It is in the bundle. I've seen it. And then you go and say that. Yes,
I think it's page 7433.
Oh, thank you. I'm grateful. I said you'd be repaying me. Thank you. And do you have the McCandy one as well? Then the McCandy case, I think, must be the next one along. Yes, it's at 28. So there's another case. The next case along is 7418. Just found my way back to the transcript. Right, so I was looking at page 615, the middle paragraph where the judge says it would have been there would be no difficulty in finding an abolishment of I think he means acknowledgement of service, contesting the jurisdiction and making the necessary applications. Then there's reference to this McCandy case I just gave you the reference to. and the approach of defendants. I won't read that out because the court can read that in its own time. And then you also then have at page 37 of this transcript, which is at page 1620, at the top of the page. The judge also distinguishes the Uzan case. He says, unlike Uzan, this is not an appeal from an order made by an inferior court. This is an application made to the same court that has already granted the injunction, having given the defendants a full opportunity to appear at interbody's hearing, which they chose not to take up. And then he deals with a question which wasn't brought to your attention yesterday, and that is the question of change of circumstances. Because he said it's said now on behalf of the defendants that there is a material change of circumstances because one set of Kuwaiti proceedings has been dismissed, namely the proceedings which were relied on by the claimants when seeking injunction. It is, however, clear on the evidence of both the Kuwaiti lawyers instructed by the parties that these proceedings were dismissed on the 21st February. That was because of the inability of the claimants to serve one particular defendant, called Cubic, with the result that fresh proceedings numbered 4701/2022 were issued. In other words, it's the inability to serve. That's the issue. And then he says there's therefore no material change which favours the defendant. The latter case has now been referred to the department for experts. And then he goes on to discuss that. And then he said, and then looking at page 1621, second paragraph, and much of the same sort of point arises in relation to the other Kuwaiti proceedings. He says, although they're dismissed, they're now before the Court of Cassation, which is indeed the position today, with argument as to the form of proceedings, so rather than the substance. And so he says the effect of all this, in my judgment, is that unless the defendants can establish there is no jurisdiction in the court at all, so that's the essential jurisdiction point to grant a worldwide freezing order, no challenge should now be heard by this court without the defendant first purging their contempt. So in other words, it was always open to the defendants to say, fine, we'll purge our contempt, we'll provide some information. So he gave them that option, but they didn't take it, and they still haven't taken it. There is in my, and going on to page 1622, there is in my judgment a distinction to be drawn between the jurisdiction of the court to make a particular order and the other matters which go to the questions of expediency, which is the discretion point. And so that's and now we understand, having looked at the Uzan cases and having looked at the way the courts put this, why that's an important what's the important distinction to make, and a very fair one to be made. Now, I don't, as far as I'm aware, I don't believe the issue in relation to material change of circumstances is actually a ground of appeal. But at either rate, the judge is correct to have made that finding. So, having looked at the transcript, let me just summarize why we say the court's decision, the judge's decision, was right in relation to his exercise of discretion. So the first point is that this case is very different to the Uzan case. The proceedings before Justice Cook were not an appeal from an order or an appeal from contempt. They were an attempt to set aside the injunction late. The second point, which I don't believe is, yes.
I understand that distinction, but why is it relevant?
Well, because yes, I mean it's relevant if a court is listening to an appeal from contempt, it may well want to listen to all matters. But if it's a set aside application that's being made after a party has had an opportunity already at a return date, and indeed at any time from that point for 9 months, then that's a very different situation as to one being made in time. In Uzam, a second point is that in Uzam there was some compliance. Now, and this point has been made in our outline of submissions, our latest document, and that is so often parties make some kind of token effort to comply, and then will claim that they've complied or they've materially complied, and they try and seek some indulgence from the court. This case is extraordinary because there's been no compliance at all. And that takes it outside the Uzan case as well. It makes it different to Uzan. And of course, we have the whole issue of the abuse of process and the material change of circumstances. My learned friend yesterday said, well, Mr. Justice Cook, when he was dealing with Uzan in one of the Uzan cases, allowed the defendants to make submissions regardless. But as I say, that was a situation where there was some compliance, and he only did that in relation to a cross-examination, an issue of cross-examination, where they could explain why they didn't turn up. There may be some kind of reason why they didn't turn up. This is very different from our situation, where the only reason for non-compliance is they thought the application was frivolous, or the order wasn't binding upon them. So that's the first point. The first point is this present case is different to Uzan in material respects, and the timing of the application is one of those, and the failure to comply at all is another. The second point brings us back to the jurisdiction point, that the judge was right to make the distinction between essential jurisdiction and discretion. They didn't, because they didn't take the point about anything when they could have done. So they should not be allowed to take any point before. We saw this citation from G. They didn't file acknowledgements of service, and that's the RDC Rule 12 point, when they could have done. And they would still be in contempt regardless, because as we've seen from the PwC case and the G citations, and indeed the Uzan paragraphs 148 to 50, if the order is made and there is essential jurisdiction, then it needs to be obeyed. They're still going to be in contempt. And I mean, we say, of course, and you've seen my submission, you've heard my submission on this. We say in any event, the order was correctly made. The court exercised its discretion properly and appropriately, based on the test that he needed to meet in relation to jurisdiction. And I won't rehearse all that again. Now, my learned friend says, well, it may have a relevance to the contempt penalties. There may have been less, but there's actually no authority to suggest that if it turns out that an order shouldn't have been made on discretionary grounds later on, then the contempt sanction should be less. Certainly no authority, particularly when those applications have been made well out of time. And what we say as a matter of submission is that it's not a plea in mitigation for a party in contempt to say, well, if I turned up as I should have done, I may have persuaded the court not to exercise its discretion to make an order. That's not a plea in mitigation in contempt. So that's a second reason why the judge was right, because that was a correct distinction to have made. The third reason is that there are specific aggravating factors in this case which go beyond mere non-compliance. There was, for example, a blocking of the solicitors by Yasmin al-Saleh when served with the proceedings, which is a literal contempt. It does show contempt in an ordinary use of that word, and one can see that from the affidavit at 4021. There was also, prior to the hearing before Mr. Justice Cook, an email from the registry sent to the parties, which explained in terms that the defendants were in contempt and that they should be purging their contempt. And you can see reference to it. I don't see the actual email, but of course it'll be the registry will have it, but you'll see reference to it at page 6005, paragraph 1.3, which is our skeleton argument for the hearing before Mr. Justice Cook. So that's an aggravating factor. They were given warning by the court, but chose to ignore that warning. They still showed up at that hearing, having made no effort at contempt and insisting that the proceedings were frivolous. The evidence for the luxurious lifestyle, I'll just give you some references, is at 5732 and 4417, which we say is an aggravating factor. And then we turn the frivolous references at 4821 paragraph 79, but we looked at that yesterday. Then there's the interest of justice, which, as you can see, Mr. Justice Cook took great care to have regard to and applied that. And the interest of justice, of course, works both ways. We would submit, not be fair on the claimants to force them to deal with all points which effectively are water under the bridge, or when they were prepared to do that at the return date. They had this order made in their favor. They've relied upon this order. They sought to enforce it in other jurisdictions. They at that point they had attachment orders in France. There were processes in place, or about to be in place in other jurisdictions. It would be unfair and not in the interest of justice to force them to have to deal with each of the points. There are numerous points. The skeleton arguments in this case have been very long indeed, as the court will note, both before Mr. Justice Cook and before this court. To have to deal with all these points, every point that's been taken. And similarly, a suggestion was made yesterday that this matter in relation to discretion be referred back to the judge. And in our submission, this too would not be in the interest of justice and would be deeply unfair to the claimants who've had to put their hands in their pocket to fund these proceedings and have been forced to spend this money when the defendants could have, if they had any basis for challenge, shown up earlier. So that's the third point, aggravated factors. The fourth point is that this is all a matter of discretion. Now, my friend accepts that, but actually that's not really been addressed adequately. If we can go to page 6761. And this is a case of Fidel and Felicia of the DFC Court of Appeal, and I'm looking at paragraph 24, which sets out very neatly how a court relates to matters of discretion. So the court is aware that decision being appealed against the case management decision, as a general rule, a case management decision should not be interfered with by the appellate court unless it's satisfied that the judge below had erred in principle, taken into account irrelevant factors, failed to take into account relevant factors, and came to a decision so plainly wrong that it must be regarded as outside the generous ambit of the discretion entrusted. So taking each one of these in turn, I don't hear anything from Mr. Liebeter to suggest that the judge erred in principle. He suggested the judge got it wrong by finding that some of the authorities conflicted. Well, we don't think he is wrong about that, but regardless, he applied the test in Uzan, and the interest of justice was central in his mind, clearly. That he took into account irrelevant factors. I haven't heard any suggestion as to what irrelevant factors were taken into account. We say all the factors were clearly relevant. He failed to take into account relevant matters. I've not heard any argument as to what other factors the judge should have taken into account when deciding not to hear the parties, the defendant parties, and that he's come to a decision so plainly wrong. And given the fact that the court clearly has discretion, and the court did in fact hear the parties on the essential issue of essential jurisdiction.
I think you concede the had no alternative on that point. That wasn't a matter of discretion. He had to hear the parties on the essential jurisdiction point.
Well,
I thought you up to that. Yes,
that's true. Well, that would go to my point about being generous. You would say to me, it's not being generous. He needed to do that, and if that's the case, and I can see why that is, and then he did that correctly. But it's certainly in relation to the other matters fall within his discretion, and he exercised his discretion not to hear them. And if one reads the transcripts, one will see that Mr. Prasivka did his level best to bring these points to the attention of the judge in any event, but nevertheless he exercised discretion, and we say he was well within his rights to do that, following the Uzan principles and given the points that I've made so far. And the last point on this in terms of discretion is as matters stand today, this court can also, of course, look at factors that have taken place until now. And I won't rehearse all the facts that I've said before, because the court will be aware of what has taken place since the Chief Justice's order allowing this appeal. And one point which is particularly troubling to us is that the amounts that were paid into court relate to amount in dispute. And if I can take you to page 3035. This is the E&Y report of 2020, which looks into the assets of UEL. And if you look at paragraph 416, you'll see that the asset purchase agreement sequent purportedly, right, the word purportedly is interesting there, sold the following assets to ASPTC. And then you have all of the issued shares of Candlewood.
Purportedly simply means that's what appears on the documents, and he's not making a difference either way about whether it's true or not.
Yes, although there are other statements in this document which raise several concerns. But the point, and I'll kind of go. I should show you those since I'm here now, and the point you've just raised. But you'll notice the reference there to Candlewood, and so the evidence that our latest evidence is that there is an issue in relation to the assets of that company, and we say we have a beneficial interest. And so the concern is that monies in which we have a beneficial interest are being used to satisfy the order for security for costs in these proceedings. And then we have the separate issue that the defendants then request that this court make a declaration. That's refused. Rightly, because of course they also applied earlier for a stay, which was refused. And then after that decision not to make the declaration, they then apply to the local courts in Dubai to stay the enforcement of the order requiring payment to us of $250,000. So, what we say about that is the court can take into account this kind of behavior as well when deciding, because it of course exacerbates the contempt. Now, since we're on the E&Y document, if you go to 3025.
3025.
Yes. The document's not coming up for me. I don't know about you.
Yeah, neither do mine.
Okay, I don't have it, unfortunately. Let me try again.
Okay. Executive summary EY.
Right. I've got a little bit of a problem with my bundle, but I'm just reloading it. Okay, 3025.
Executive summary.
Yes. You may just want to read that while it's loading, particularly the last point on this on the slide, on the page.
I haven't got it yet.
Okay. Do you have that now, my lord?
I don't.
Ah.
I can look at it later if you tell us what you want to take from it.
That's probably beneficial. I mean, it's an executive summary with various bullet points, but there are two that I draw your attention to. The last two on the page. One of them says the liquidators' investigations have not identified any assets or bank accounts that are currently under the ownership or control of the company. So the company has nothing. And then it goes on to say, based on the initial investigations and a review of the company's records, the JOLs are of the opinion that there are certain transactions involving assets that may or may not still be legally owned by the company that require investigation. So there's real questions to be asked. And then if you go to page 3031,
Mhm.
It's very slow for me. It's not coming up. Here it is.
Well, once you're in the document, it's probably easier just to scroll down.
Yeah, okay. Yes. Maybe doing that. 3031. It talks about the CPWIT transaction. So according to an asset purchase agreement, and then it explains the transaction. And then it says that he was executed by ACNID on behalf of both CPWIT, and it's not apparent in what capacity executed the agreement on behalf of each party. And then what you can see is this company was then dissolved shortly, not that long after the transaction. Similarly for the Madhani transactions. And then the last point on the page is that the company does not appear to have convened annual general meetings and provided members with annual books of account for over 20 years in contravention of its articles. And so the point that I'm making is that I mean, the main point the reason I brought you to this is just to highlight the Candlewood reference. But what Ian Weiss certainly are asking for is further information. There seem to be certainly some questions to be answered and suspicions. And what we say is we've seen no evidence explaining what has happened to these assets and why is this related party transaction in relation to CPWIT and Madhani, and where these assets are and where the consideration went to to prove that that's being paid to the company. So that's all I want to say in terms of discretion. We say the judge was right to exercise it in the way that he did, and essentially that, in our minds, brings an end to this appeal. But my learned friend raises other arguments, and there's a whole now host of arguments which I'm going to need to deal with, which really all should have been dealt with at the return date. So what he says is, even if vacated at the hearing, was he said that the Kuwaiti proceedings have been dismissed. Well, they haven't been dismissed, as we've seen. There's been a switch of case numbers, but as Mr. Justice Cook found, no material change of circumstances. And as I say, I've not seen any reference to that being wrong. So they haven't been dismissed. And in any event, it doesn't matter, because as we saw in broad idea, there just needs to be some possibility of a judgment. And of course, these proceedings were reinstituted in Kuwait, and there are a second set of proceedings which are also on foot. And if there's any doubt about those proceedings, there's also the French proceedings which are on foot. And very importantly, in front of Mr. Justice Cook, at least in the skeleton arguments, there was no there was no points taken in relation questioning the French proceedings having been dismissed or anything of that sort. And so, even if there was an issue in relation to Kuwait, certainly no issue in relation to France. Mr. Liebert yesterday said there's no evidence anywhere how it will work. I believe he said that. But if you go to, and I won't ask you to go to it now because I don't think it's material enough. But if you look at 1805, then you'll see that counsel in Kuwait explains exactly how it works in relation to the expert report and how a claim gets developed following that. And indeed, Mr. Justice Cook said he was familiar with that process. So that's the Kuwait proceedings dismissed case. There is also an admission by the defendants in their skeleton argument for the appeal at 690, paragraph 620 and 21. I don't have to take you to that either, but they say that it could result in a money judgment. Their complaint is there's no money judgment being asked for, but they admit that it could result. Their whole point is that it may be one stage down or two stages down, and we say that's not material. A point was made yesterday about quantum. If one goes to page, yes.
Just to be clear on this, if Mr. Liebert would say when, but if the Kuwaiti proceedings are eventually dismissed and the French proceedings are eventually dismissed, and it may not happen, but if that happens and there are no other extant proceedings in other countries, then presumably the defendants would be entitled, notwithstanding, even on your argument, notwithstanding their earlier contempt, to come to the court and say there's nothing underpinning this injunction anymore.
Absolutely. In fact, if that happened, in other words, if all the proceedings are dismissed, like you say, we would have an obligation, I would submit, to come back to this court. I mean, we wouldn't, you know, we would be expected to come back. Maybe it's not the obligation, and we would do that, unless my solicitors tell me otherwise, to say that the order needs to be set aside.
You say unless your solicitors tell you otherwise. I hope, even if they did tell you otherwise,
no,
in procedural court. But
I'm just covering myself. Yes.
If for some reason you didn't, then the earlier contempt would not prevent the defendants coming to court and say it should all be set aside because.
No, but by the same token, they would still have been in contempt all that time. They can't escape that fact. At page 1564. This is a discussion in relation to quantum. I believe Mr. Leavetter said, and I apologize if I got this slightly wrong, but he questioned what he said. He didn't understand how the quantum got worked out. There was actually a very detailed discussion with the judge about this, and this is the basis for it. The company was valued at 166 million in 1999. That's what we're told. That's what the judge noted at 1564. And then the way he works it out is we are entitled to beneficially 13.1% of 166 million. And then he applies a percentage rate year on year in terms of interest. And then he arrives at a figure, which is the figure which is in the order. So that's how the quantum is worked out.
As far as the quantum is concerned, Mr. Leavetter, do you accept the judge's way of calculating the quantum?
No, Your Honour, we don't.
Okay.
I mean, in relation to that, it's not surprising because the defence don't seem to accept anything. But of course, our answer to that is, if they had an issue with the quantum, they should have raised that before the judge at the return date, or any point since then, and indeed even before Mr. Justice Cook. I don't believe that they were taking exception to the quantum, and I'm not even sure there's a ground of appeal in relation to that. But I'll put that to the side for the moment. If I can take you now to page 2271, which deals with a point raised by my learned friend, because he mentioned the share agreement, and a 2271 is the clause which gives non-exclusive jurisdiction to the Cayman Island courts or the Commonwealth of Massachusetts courts. But the short point in relation to this is this is not a shareholder. It's not a claim under the shareholder agreement. One thing that's noteworthy about this clause is that it doesn't have a clause which says any claim in relation to or arising out of this contract. It just says this agreement, this particular agreement, shall be governed, interpreted, and enforced in accordance with the laws of the Cayman, except the Enforcement Reserve. And each party agrees to submit to the jurisdiction on a non-exclusive basis. So there's non-exclusivity. It relates to this particular agreement, and the final point in relation to this is the parties to the claims in Kuwait and in France are different. And essentially, what we're looking at is a conspiracy type claim, which simply says there are monies that are being dissipated to which we're beneficially entitled, and we say that's been done purposefully.
Isn't in a breach of this agreement?
Well, often you can have a breach of an agreement, and you can also have a separate claim in fraud or negligence,
or tort, or...
yes, or in tort, exactly. And that's not uncommon. And again, at risk of repeating myself and being told off by Lord Glennie, all these points could have been taken at any point in time and debated in a proper way rather than now on an appeal. They then talk about
in your proceedings in France or Kuwait, do you rely upon the the shareholders' agreement?
I don't believe that it's relied upon. I can only say I don't believe, but I will take instructions on that. But I don't believe they do. Those proceedings do rely on that.
Right.
The next issue is that it's a claim for reflective loss. Well, we say again they didn't take this point, but it's a fraud claim. It's not. This is not a claim. It's been shoehorned into a. Mr. Liebert, who wants to recharacterize what the claims actually are. Those aren't the claims that are being made. Plus, it's under Kuwait law, and applying Kuwait law, there is no problem in relation to reflective loss, and this court would apply, understand that, and there's no issue in relation to that. Then interference with the liquidation. Well, there's been no complaint by the liquidator. If there's any money that needs to be accounted to the liquidator, there'd be accounted to the liquidator. And again, they lost the chance to make that point. Statute barred. They say we're statute barred. Well, the problem with that is they admit, again, I won't take you to, I'll just give you a reference, at 7609, that if you discover a fraud later on, then the time starts running from the time that you discovered the fraud or could have discovered the fraud. It's a similar principle in England. And our position has been that we came to understand and know about the Metternich and Seaprint transactions after the 7082 transaction, application in the US, which happens within the period. And to the extent that these statutes are in any event relevant to the application for interim relief. In other words, we're covered in any event. And in fact, we go further, because this point was made to the judge at 5 in our skeleton argument. There's a whole section of full and frank. Interestingly, one of the points my learned friend doesn't make is that we weren't full and frank. And we say that this really supports a lot of what we're saying. Many of the points that have been made, including connection to the DIFC, including statutes and limitations, were all put to the judge in full and frank. The other side saw these arguments. They could have come back, and you can find that at 5942, which is our skeleton argument, paragraph 4.1c. Then they say that their next ground is ground 4, where they say the judge should not have found contempt. And I mean, our simple answer to that is, of course, he's going to find contempt, because, and again, risk of repeating myself, once the order has been made with essential jurisdiction, it's binding. And they're in contempt. There's no way around it. Plus, given the fact that the defendants have made no effort at all, there's no issue of any mens rea. In other words, intentionality. Indeed, they say we do not consider this order binding. That's the reason they considered it frivolous, to use their language. That's the reason they didn't comply with it. So the contempt bit of the application is very easy, because there's just no excuse given. And indeed, a point I mentioned at the outset of my submissions is that there was no, as far as I can see, formal defense to the contempt application. The way that the defendants responded to the defense application was by making a set-aside application. But we say that was misconceived, because even if they succeed in the set-aside, they'd still be in contempt unless they could somehow have the court say this was void ab initio, which we would say was going to be an impossible challenge from the outset. So the court wasn't wrong. His Excellency Madhani yesterday raised an issue of the amount being ordered in sanction. I'm not aware that the other side have actually challenged the particular amount. What they say at their ground 4, and I may have read this wrong, is that they shouldn't have been a finding of contempt at all. And there is some reference to intentionality, which I frankly don't understand. But what we say is that the judge has discretion, which has to be exercised appropriately. But this is a very, very serious contempt for all the reasons that I've already said and won't repeat. Moreover, in the order sanctioning and ordering payment, firstly, the judge was very careful not to order a same amount be paid by each of the defendants. So he took into account their personal circumstances in life. He took into account the fact they're very wealthy, which they clearly are, and I don't think there's any dispute about that. We don't know how wealthy they are because they haven't complied with the order. But more importantly, he gave the defendants a chance to pay the amount and not have the second part of the order by a particular date, and not have the second part of the order bite, that is reference to the Attorney General. So provided they purged their contempt and paid the amounts of the fine, then they could walk scot-free. And they chose not to do that. And we say, firstly, it was generous and fair of him to make an order in those terms, to give the other side extra time. But in fact, there is some discussion in the hearing about the date for compliance that was pushed back to give the defendants more time for compliance. But in the event, they didn't comply at all with that particular part of the order. And so it was right that they were found in contempt, and their behavior subsequently has shown that it was right. It is worth taking the court to another part of the case in Latif. If you go to page 711.
This is Latif, is it?
Yes. But it's not the same Latif as the one which dealt with jurisdiction. This deals with the contempt, which was in that case.
711.
711 is where it's, yes. And in fact, you need to scroll down slightly because I want to get to paragraphs 138, which, if you want to put the number back in, it's 725.
Mm-hmm.
No, sorry. Yes, this is about the disclosure obligations. So senior counsel of the defendant submitted that the continuing failure to provide adequate information with respect to their assets should not be regarded as significant, because the assets which they had ultimately disclosed would be more than sufficient to satisfy any judgment. So one point here you can see already is, again, this is a typical case where there is some disclosure, but it's not adequate. But the judge wasn't persuaded in this case at all. So with respect, that submission misses the point, and then quotes cites from Mr. Justice.
What paragraph you're reading, Mr. Paul? Sorry.
Paragraph 139. So it's page 725, paragraph 139.
Whose judgment is this?
It's actually Justice Ali Al-Madhani's, so His Excellency's.
It can't
Yes.
be, because you're quoting from Justice Ali Al-Madhani. Oh, really?
I don't know. I was assuming that, but maybe I'm wrong. It's SBM Bank, but you can see what it says. You know, freezing injunctions serve two purposes. The firstly, to prevent the dissipation of assets in the hope that any liability is determined by the court. So again, you can see the future hope. And then you can see what it says middle of the paragraph. The importance of the information element is of particular importance in cases where a party is accusing another of fraud or wrongdoing, so not necessarily fraud, but any wrongdoing, and is seeking to trace back assets before they were dissipated. It's most of the case that the wrongdoer has very little left in the way of evidence, and so the claimant seeks relief from the court in the form of provision of information under the terms of a freezing injunction to piece together events and trace their assets. So you know that this court has recognised the importance. Now, if I can take you back to 711.
It's for the record that this is Justice Wayne Martin giving judgment, quoting.
Ah, yes.
Thank you.
Thank you. Yes.
You want to go back to what?
Page 711, which is I want to look at paragraphs 10 to 18. Yeah, so paragraph 10, so it's at page 711 at the foot. You can see contempt general principles. So the judge, Justice Wayne Martin, sets out Article 43. Then he refers to a case about contempt. And that deals with criminal jurisdiction. So the court doesn't have criminal jurisdiction, but of course it can refer matters to the Attorney General of Dubai. And then talks about the onus of proof at 14. And then at 15 talks about what's required in terms of the mens rea. So the conduct giving rise to the alleged contempt must have been the knowing and willful act or omission of the alleged contemner. And it's important to emphasize that the mental element required to establish breach applies only to the act or omission said to constitute breach, not its consequences. So in this case, all we need to show is that the defendants know they're not providing information. But in fact, they know much more than that. They know they're breaching an order. They simply don't believe the order is binding upon them. And they're also, we assume, because they've got lawyers everywhere, it seems, or many places in the world, that they're being well advised. Then there's a citation from Aldridge, Eady, and Smith at 16, which deals with the intentionality. And then at 10, then yes. And then the judge then goes on to talk about sanctions later down the page and mitigation. And it refers that from 30 onwards to the defences that were before him. But the point here is that, as I said before, there's nothing in here which suggests that any failure to exercise discretion properly at some point would assist. The things the court can take into account is if there's no apology, no purging of contempt, and the like. And in this case, we would say is an extreme example of contempt. In fact, it's hard to imagine a stronger case for contempt. It's hard to imagine what more a party can do other than completely ignore everything a court says, block the accounts, block WhatsApp messages and the like. And so if we look at the transcript to see how the judge views all this, it's at 1750. It's a foot of the last paragraph on the page of 1750, where the judge says that what he's persuaded to do, to impose a fine and a reference to the Attorney General. But as I say, he was kind in the sense that he wanted to suspend their operation of the reference to the Attorney General for a given date, which in the context of payment of the fines I'm about to impose will be the 21st of December, which I believe was longer than we suggested. And he gives very careful reasoning, which hasn't been engaged in any way by the defendants in this appeal, as to why this is the correct amount and the correct order to be made. And we say that he was completely correct to make the order he did, given the flagrancy of the breach, the costs outstanding at this point in time, the wealth of the individuals who could easily pay the fines, and indeed who easily did pay the fines, although we say with money owed to us, given the amounts in issue, given the position of each of the defendants, given his allowed suspension to the reference to the Attorney General, and the longer time to comply with the order, and the warnings that were made by the registry or given by the registry on the 12th of September. And as I say, I don't believe this level of fine has been appealed. And so we say the right order for this court to make is that the judge did have, this court has essential jurisdiction. It does need to be applied appropriately at the discretionary, in terms of discretion and following principles of expediency, and the court can and should look to common law rules, including the English authorities that have been cited. But nevertheless, the judge was completely correct in exercising his discretion on the USAM principles to exclude submissions about that. But even if he hadn't excluded them, in other words, had exercised his discretion was properly exercised, having regard to the international nature of the claims, the international position of the clients and the distribution of assets, the serious wrongdoing that has been alleged and which hasn't been challenged, and for which there is at least prima facie evidence, the conduit jurisdiction of the DAFC court, and the right to apply for orders for to secure future judgments, and given the fact that these defendants never appeared before the court and didn't put in acknowledgements of service. And that's the result that this case should have, we submit. And then the ground 5, of course, falls away. Arguments in terms of discretion in relation to costs. Well, costs are in the discretion of the parties, but let's suppose that even if the defendants are correct and they win this appeal, we would submit we should still be entitled to our costs. Why have they waited so long? Why have we had to go through this whole process? So we do say it's remarkable that the defendants could at this point say they actually want all their money back and for us to pay their costs. It is a remarkable submission, and actually borders well, I won't say. It's just a remarkable submission. And then there was a point in the grounds in terms of alternative service. It's not, we don't understand why that shouldn't have been ordered. Again, it's not a point that I believe was taken before Mr. Justice Cook. It forms part of the grounds, but I'm not sure that Mr. Leabeater actually dealt with it. Anyway, it makes no difference now. The parties are before the court. So for all those reasons, the court should find in our favour and should not have a difficulty with that. And indeed, we do say that should the court not find in our favour and come to what we would say was a remarkable decision that the court doesn't have the same unqualified jurisdiction as an English court or other courts of common law, then we do fear that the reputation of this court may well be harmed by that, because it would severely limit the jurisdiction of the court and also undermine much of the case law that is developed in a very considered and careful way, including Latif, including the Nest judgment, including
I think the submissions about the reputation of the court don't come very happily from the bar. Yes,
I will not make them then in that case, and I withdraw those to the extent that I can, and I will not continue on that line. The point is taken, and I apologise if they caused any offence. In that case, unless there's any further questions, my submissions are finished for now.
Can I just be clear? Sorry, Chief Justice, can I just ask a question?
Please, sure, please.
Just on the question of costs, I think your primary position is you should get your costs whatever happens. Is that right?
Yes.
But if even if the court found there was no essential jurisdiction, in other words, the first point we've been arguing, you still say you should get all your costs, including the cost of making the application?
Yes, because that point still could have been raised.
No, but
it's still not. We would still say it's still not open to a party to sit back and do absolutely nothing and hope that the court will be its gatekeeper for it. That's still not an appropriate response, and that's the sense of the cases and the authorities that I took the court to.
I see.
But if it is your error in making a wrong filing, what you did was wrong, assuming we hold against you, why should you penalize the other party?
I think that would firstly I would think that even if it's, I would say as a matter of submission that even if it was wrong, then in a situation like this it would still be the right thing to do to have the cost. But we'd say it'd have to be an extreme situation where a court would come to that decision. And in other words, be completely and wholly unarguable. And given the existence of the Latif cases and the Jones cases, and indeed the response of the judge, we say that that's not the situation here. And of course, I've gone further and said the court was right to exercise its discretion.
Mr. Leabeater?
Thank you. I know it's is it 10 to 2 in Dubai? Whether you'd like me to start, and I've probably got about an hour to go, I would have thought.
Yeah, I think it's okay for me. What about you, Judge Ali? Are you happy?
Yeah, that's good for me.
Okay.
Yeah.
Although I think 1 hour is a lot, but it's okay for me.
I'll try to be less than an hour. I will try to be less than an hour.
Fine, thank you.
Right.
Okay.
So may I start with one very minor point, just so that you have it for the benefit of your note, because it is difficult to find your way around. The judge's judgments at first instance, first of all, his decision on the issues that he would hear, the reference for that is page 1611.
1611, okay.
His judgment on jurisdiction is 1669.
Okay.
And his judgment on contempt is 1750.
Okay.
So those are some references. Now, on to the main point, that of what's been described as essential jurisdiction. My learned friend, Mr. Bohr, says the issue for the court is whether the court has essential jurisdiction to grant injunctions in support of foreign proceedings. I would respectfully disagree that that is the issue. We accept, indeed, that the DIFC court may have jurisdiction to grant injunctions in support of foreign proceedings, so long as the court has jurisdiction over the relevant defendant under Articles 5(1)(a) to (d) of the JAL. There is no, however, in my submission, there is no general freestanding jurisdiction to grant injunctions against the world under Article 5(1)(e), whether by reference to the court law or the RDC. And I'll come on to those in a moment. It's also become clear that there is a fundamental point which has to be borne in mind, that there is a difference between the jurisdiction of unlimited inherent sovereign courts and the jurisdiction of statutory courts like the DIFC. And cases dealing with the inherent jurisdiction of sovereign courts or unlimited courts, cases dealing with that jurisdiction may not easily translate to a limited statutory court like the DIFC. So I give you an example from my recent practice. The Admiralty Court in London has prima facie jurisdiction over every vessel sailing over every part of the high seas all around the world. However, the difficulty, as His Eminence Justice Al-Madhani points out, is getting permission to serve out. Because if you can't have a defendant who is either within the jurisdiction or in relation to whom you can satisfy a gateway for serving out, then although there might be jurisdiction, prima facie jurisdiction over every vessel sailing over every part of the high seas, you're not going to be able to exercise that jurisdiction because you can't serve out. That sort of inherent sovereign jurisdiction is not the jurisdiction of the DIFC court. Next on jurisdiction, can I pick up a point that Lord Glennie asked about what Rule 12.5 means on deemed acceptance of jurisdiction, and in particular what the notes in the DIFC court practice meant. We have now uploaded a slightly different section of that book to the appeal bundle, which gives a slightly clearer answer. Could we look at that, please? It's in page 7844. So 7844 is page 9 of the DIFC court practice, and the front piece is the preceding page, just so you can see where it comes from. And we can see that in relation. Sorry?
Page 9. Page 9.
Sorry, I'm so sorry. Page 7844. 7844.
No, page 9 of the book, is it?
Oh, it's page 9 of the book.
Yeah.
And there's a helpful chapter in there on jurisdiction, and one of the subtopics the book deals with is submission. Makes the point that DIFC court's jurisdiction is exclusively statutory, refers to the Akhmedova case, and then refers to the case of Hart, a decision of, in fact, not Sir Anthony Coleman, but Sir John Chadwick, which it's worth. But anyway, it refers to that decision, and sorry, and goes on to say that Chadwick found that the submission to the DIFC court by, for example, defending on the merits or by operation of 12.5 could not confer on the court jurisdiction which it did not otherwise have. And then he cites various different decisions, including investment group, which I'll come on to in a minute. And then the book says this: submission could operate only as a waiver of objections that a party might have to the exercise of the court's jurisdiction. For example, as a result of an exclusive jurisdiction agreement in favour of another forum. The JAL has since been amended to confer jurisdiction by agreement between the parties. However, the position appears to remain that submission cannot create jurisdiction unless the acts relied on satisfy the requirement in Article 5A2 for a jurisdiction agreement or otherwise meet the requirements of one of the other gateways to jurisdiction.
That statement is made by the editor. Who wrote this part of Montague Smith's book?
Yes, I can't remember.
James Wheel. James Wheel.
Yeah, James Wheel of Searle Court.
I'm very grateful. Could we look at the what's probably the leading case, because it's a decision of this court, the Court of Appeal in this area, yes, which is investment group, and we see investment group at page 7798.
7798.
Now, this was a number of cases, Your Honours, which considered whether an exclusive jurisdiction clause conferring jurisdiction on the Dubai courts is capable of including the DIFC court. So the issue was whether exclusive jurisdiction clause in favour of the Dubai courts was capable of including the DIFC court. And there are a number of decisions in relation to that, as at least some members of this court will be aware. And the DIFC court has generally found that it is, since the DIFC court is one of the Dubai courts. Now, in that case, a concession had been made at first instance that the DIFC court had jurisdiction, and new counsel on appeal sought to withdraw that concession. That led the court to deal with, as a matter of principle, as whether a concession in relation to jurisdiction should be capable of being withdrawn. And we picked that up at page 7813. For
some reason, I can't get this case. Has it just been added to the
It was this morning, yeah. You might need to refresh your...
I can't get either.
Oh, I'm so sorry. If you refresh your bundle page...
What was it, 77?
7813.
No, the first one, the earlier one.
Oh, the earlier one was 7844.
7844. Okay.
If you refresh the whole page, which has the court bundle on, then you might then be able to get, I hope, 7813.
I've got it now.
Great.
How do you refresh? I'm not sure.
Yeah, good question. If you look, it depends what you're doing. If you look at, depends on the browser, there might be a little round circle with an arrow to the left at the top.
Oh, I see.
Or also F5.
Hamad, can you take note of this and you can email me or us separately?
Yes.
Pages 7844 and 7813.
7813, yes.
You got that? Hamad?
Yes.
I got it. It's on my screen.
I can't get. Never mind.
You wanted start at 7798. What page did we wanting?
Yes, 7813.
I think it's number 3 in tab Q, additional authorities.
That's right, yes. But I think the Chief Justice problem may be that his link is an old link and he needs to refresh it.
Or it could be an old link there, side. I have to go to the new link. I have to refresh all over again. Okay. This is something our IT must look into, Judge Ali.
Sure, yeah, I will.
No, our IT must look into that. If you add in a document after filing date, then how do you overcome that problem?
If you refresh, yeah, you would have it.
You have
do you see the refresh icon in your screen?
What does it show? How does it show up? What is it refresh?
It's like a circle with an arrowhead.
Okay.
Press that.
Let's see how it goes. Okay, just anyway, go on, go ahead.
Okay. So if we look in paragraph 58 of the decision, they refer to the decision of Hart, again referring to the wrong judge, which may be where the book picked it up. Consider the effect of Rule 12.5 of the rules of the DIFC court, where a party has failed to make an application disputing the court's jurisdiction within the specified time. Justice Coleman held that the consensual submission to the court's jurisdiction contemplated by the rule cannot extend the scope of that jurisdiction beyond that accorded under the national laws that confer jurisdiction on the court. And then they refer to Talim. I don't think I need to go into that in detail, but then paragraph 61, they say this: the principle that parties cannot by agreement bring a dispute within the jurisdiction of a court where the case does not come within the delineated ambit of the court's jurisdiction is well established. And they refer to a case called Essex Incorporated Congregational Church, where Lord Reed said it is a fundamental principle that no consent can confer on a court or tribunal with limited statutory jurisdiction any power to act beyond that jurisdiction, or can stop the consenting party from subsequently maintaining that such court or tribunal had acted without jurisdiction. Then paragraph 62, the Court of Appeal, the DIFC Court of Appeal, says the purpose of the principle is to give effect to the legislation or other instrument establishing the court's jurisdiction, the delineation of which will have been responsive to a number of important considerations, including, in the case of a national court, the relationship between that court and other courts within the same polity and or other external courts to whom principles of comity should be extended. And so that was the basis upon which the Court of Appeal in that case said that jurisdiction could not be conferred by either consent or by a failure under Rule 12.5 to file an acknowledgement of service in time, and they permitted the concession to be withdrawn. They then went on to...
What case is this?
This case is a case called Investment Group. Investment Group against Standard Chartered Bank. It's a decision of the Court of Appeal, the 19th of November 2015. Chief Justice Michael Wang, Sir Richard Field, and His Eminence Justice M.R. Omayahari.
Okay, yeah, I remember that.
Mr. Lieber, can I just...
Investment Group against that, yeah.
Can I just be clear on one thing? This is 2015, I think, this decision.
Yes.
Was Article 5 1A 1E in force at the time? That is to say, the one that refers you to DIFC regulations.
I think the wording is the same.
Yes.
I tell you why.
So. I have to check. I want to check.
Wondering whether there could have been an argument that the Rule 12 or whatever it is that says you consent to jurisdiction if you don't challenge it properly could have been taken by reference to the DIFC rules and regulations under paragraph E. Anyway, apparently not.
Well, it wasn't a point that was advanced, and in my submission that would be quite a difficult argument, because that would be conferring jurisdiction but by a failure to do something in circumstances where no jurisdiction has been conferred under the law itself. I mean, it might be that a law could be written to do that, but it would have to be very clearly written in my submission.
Yeah, I see. Thank you.
So just to make the point that in that case, the investment group, the concession was permitted to be withdrawn. The court then went on to find that it did have jurisdiction, and the concession made below had been correct as a matter of law. But in my submission, this underlines the point that I made yesterday, which to the effect that the application of Rule 12.5 can have no importance in our case. And can I also just draw to your attention on that point? Sorry, I've got a wrong reference. I just need to. Can we look at 7534? This is the rule itself. even on the face of the rule, it says if the defendant files an acknowledgement of service and does not make the application disputing the court's jurisdiction within the period specified in Rule 12.4, he is to be treated as having accepted that the court has jurisdiction to try the claim. So that is only in relation to substantive claims. But secondly, it only applies where the acknowledgement of service has been filed, but the application to dispute the court's jurisdiction has not been made. So we're not even within 12.5 at all. The position in our case is the acknowledgement of service was filed late, but when it was filed, it did dispute challenge. It did dispute jurisdiction, and then indeed the application to vacate, which includes issues about jurisdiction, was made.
Yes, there is another route to challenge jurisdiction. Well, sorry, not another, but you mentioned acknowledgement of service, but Rule 12.1 tells you what to do if you want to challenge jurisdiction, and it goes on to 12.2, which says you must acknowledge service.
Yes.
So, I mean, it's not limited to acknowledgement of service point. It's basically a default provision that if you don't take the steps required by Rule 12, then you're said to have accepted jurisdiction. But that's then subject to your point that you've already made.
Yes. Yeah. Okay. Then picking up another point that in relation to jurisdiction, which is a point of possibly some significance, again made by my Lord Glennie, about the application of forum non-convenience principles in the context of DIFC jurisprudence. Could we look back at page 7845? Now, page 7845 is within the DIFC court practice, page 13, again, for those who are looking at the hard copy, page 13 of the court practice. And it's the beginning of a section discussing the application of forum non-convenience principles within the DIFC jurisprudence. Now, I don't want to go through that in any detail, but I draw the court's attention to it in case it's of assistance. And of course, it goes to the point that I'll come back to in a moment, which is that the court may find itself dealing with an interim injunction in relation to which it has jurisdiction under Article 5A1 A to D, or indeed A to E, but nevertheless decides not to exercise that jurisdiction on forum non-convenience grounds. That might give rise nevertheless to a jurisdiction to grant interim relief in support of foreign proceedings in another place. Finally, on these sort of picking up points that were discussed in relation to jurisdiction, Mr. Bohr referred yesterday to the decision of the Court of Appeal in Credit Suisse against Goal, and the Learned Chief Justice expressed some interest in seeing that case. It has now been uploaded at page 7792, although I anticipate the Chief Justice himself might not be able to see it.
Goel
7792. So that was, yeah, that was a case where, again, it was another case where the jurisdictional clause in a contract, which is a contract of guarantee, referred to the courts of Dubai, and the issue was whether that was apt to confer jurisdiction on the DIFC court. And a freezing order application was made to His Excellency Justice Ali Madhani, you may recall the case, who held that all the grounds for freezing relief had been made out, save for jurisdiction, and His Excellency declined to grant the freezing injunction on the basis that he was not satisfied that the DIFC court had jurisdiction under an Article 5 gateway, because there was a reference to the courts of Dubai rather than the courts of the DIFC. But he gave permission to appeal on the basis that the Court of Appeal might take a different decision. And pausing there, it certainly wasn't argued in that case, so far as I can see, that freezing relief could be granted unless a gateway was first established. So that came before the Court of Appeal, and the Court of Appeal said that there was at least a properly arguable ground of taking jurisdiction under the exclusive jurisdiction clause, and a freezing order was made. And the matter then came back before the Court of Appeal again on a further appeal in relation to a finding of jurisdiction proper, if I can put it that way. And that judgment is also in your bundle now at page 7853. And the Court of Appeal held the reference to the courts of Dubai included an express choice of the DIFC court. So there was jurisdiction.
That is the interpretation of that clause.
Yeah, that's right. Exactly.
Yeah, that's all. And the word the courts of Dubai has been interpreted to include DIFC.
Exactly.
Yeah. Okay. I remember here that case.
So that deals with goal. And then finally, on a very similar point, Mr. Bohr has at various stages in his submissions suggested that you should be proceeding in this appeal not to determine jurisdiction absolutely, but only on some sort of preliminary basis. Now, in my submission, that is not the basis upon which you should proceed. Firstly, this matter has been fully argued, but secondly, and much more fundamentally, my clients have been accused of and found to be in contempt and sanctions imposed. And that, in my submission, is not something which could or should be done prior to a final finding of jurisdiction. So the court's decision below that there was jurisdiction was not a preliminary finding; it was a final finding. And the appeal that we are arguing today is a final decision in relation to jurisdiction, and so it has to be, because otherwise it would not have been proper to make any finding of contempt. Now, turning then to the points of substance on the issues of jurisdiction, Mr. Bohr puts his oral submissions at least firmly on the basis of the court law, and so I should address that. Although I anticipate that most of the points I can make quickly because they've already been canvassed in discussion with Mr. Bohr. Article 19 of the court law is where we need to start, which is page 6516. I hope.
Right.
Not quite. 6516.
6516.
Yes, it is.
Yeah.
6516.
Got it. I got it.
So part 5, chapter 1 of the DIFC court's law, well, part 5 is headed jurisdiction of the DIFC court, chapter 1 jurisdiction of the court of first instance, and article 19 mirrors with some minor and for present purposes unimportant differences article 5(1) of the judicial authorities law. And I'll just remind you the point I made yesterday that the court in DIR, D-H-I-R, against Waterfront, which is page 7652, the court held that the judicial authority law must take priority because that is the, if you like, founding jurisdiction. And to the extent there is difference, it's important to note the judicial authorities law is in Arabic as original, and the Arabic should take priority over the English, as I understand it. So Article 19, I don't think the differences between the judicial authorities law and the court's law make any difference to the present case. The point under Article 19 is that Article 19(1) sets out the jurisdiction of the court, and that is the basis upon which the court has jurisdiction. Article 20 brackets 1 is setting out the power of the court to issue orders.
What do you have? Excuse me. What
Yeah.
do you have to say to Mr. Bohr's submission that the word regulations in 19(1)(d) includes the RDC as decided in the, what case was that? I can't remember.
Nest.
Nest, yeah.
Nest.
Well, I think as I said yesterday, I accept that's what Nest says,
Yes.
and I don't seek to argue that Nest was wrongly decided even if I could, and I'm not sure what the current jurisprudence is on the Court of Appeal disregarding previous decisions, but I'm not asking you to do that. I simply say that there is no augmentation of jurisdiction that's relevant to this case that arises under either the RDC or indeed the court law.
Okay, thank you.
Mr. Libet, I mean, if you would, I would like to take your opinion on Article 6 of the Judicial Authority Law, which reads, the purpose of this law is to provide for an independent administration of justice in the DIFC in accordance with the Dubai Law number 9, 2004, and the Judicial Authority Law. The purpose, Part 2, Article 6, same law, page 6510. Page 6510.
Yes, the purpose of this law is to provide the independent administration of justice in the DIFC in accordance with Dubai Law number 9 of 2004 and the Judicial Authority Law. Yes, it's setting out the way in which justice should be administered, and it does not purport, in my submission, to expand the jurisdiction of the court at all beyond that set out in Dubai Law number 9 of 2004, i.e. the Judicial Authority Law.
And you think Article 19 must be read in the same context?
Yeah, exactly. That is precisely my submission. Article 19 is summarising the jurisdiction, but the court law does not purport to expand the jurisdiction of the court beyond that set out in the Judicial Authority Law at all. And that's why we have the mirroring of the phrases in Article 19.1, which is the principal provision dealing with the jurisdiction of the court at the first instance. And then Article 20, which is the first of a number of articles dealing with powers, sets out that the court of first instance has power to make any order, including an interlocutory order. But the point, as has already been picked up in argument, is that is in matters over which it has jurisdiction.
The
So,
other way of reading it is that the JAL is the principal legislation.
yes,
And then the this court law, this particular regulation is merely setting out the procedures to
yes,
as to how you enforce the JAL.
yes.
It's a subsidiary legislation to JAL.
Yes, whether it's formally speaking subsidiary to JAL, I'd have to look, but I absolutely, with respect, endorse that suggestion that the court law is doing something different. It is not setting out some freestanding basis of jurisdiction. It is accepting the jurisdiction as arising under the Judicial Authority Law and then explaining how the court's procedures and powers will work. That is its primary purpose, as I understand it.
Administration of justice in accordance with. In
Exactly.
accordance with. In other words, it cannot go against JL.
That's right. And so Article 20(1) makes that very clear, that it's in relation to issuing orders, including interlocutory orders, it is in matters over which it, i.e. the court, has jurisdiction. Article 21 sets out various different powers, particularly in relation to remedies. But again, that is in the course of or at the conclusion of any proceedings heard by the court of first instance, i.e. proceedings under which it has jurisdiction. And then Article 22 is dealing with, first of all, judicial review, and then secondly, injunctions. But Article 22(1) must be read in the context of jurisdiction having been set out in Article 19 and Article 22 dealing with powers in relation to matters which are before the court. The suggestion by my learned friend Mr. Ball that Article 22(2) gives rise to a freestanding jurisdiction on the part of the court to make orders against any person, anywhere in the world is, in my respectful submission, extraordinary. It would give the court jurisdiction to issue injunctions against individuals throughout the United Arab Emirates, for example, in Dubai, Sharjah, Abu Dhabi. It would completely upset and override the careful delineation of jurisdictions within the UAE that is achieved by the judicial authorities law and also the various different protocols that have been agreed. It would apparently extend worldwide, so as to include England, Israel, Malaysia, Russia, wherever else happened to be. Now, that is a lot in my submission to be spelt out of a provision which can and should, in fact, be read as simply identifying the powers of the court in relation to injunctions, in relation to matters which are properly before it under Article 19 of the Court's Law or Article 5 of the Judicial Authorities Law. And then Article 24 may also be of some signification, some significance. That deals with ratification of judgments, and it picks up Article 7 of the Judicial Authority Law and states that underneath or pursuant to that article, the Court of First Instance has jurisdiction to ratify any judgment, order or award, and then it sets out the various bodies from which that might happen. But of course, it makes it very clear, as is obvious from Article 7 itself, that that jurisdiction is limited to judgments, orders or awards which have been issued. So again, and this I'll come back to this in relation to Mr. Bohr's anticipatory conduit enforcement argument. I'll come back to that in a moment. But this Article 24 gives no assistance to him because it makes it clear that the judgment, order or award must have been issued. And then finally, because we're in the court's law, can I just pick up Article 26 2A?
You may have made the point, but if you didn't, the point is that 24.1 is simply reciting what the JAL says.
Yes, that's right.
It's not purporting even to make its own provision.
No.
Sorry, yeah.
No, that's right. Yeah, I respectfully endorse that. So then, just picking up on a question that Justice Madhani made yesterday in relation to the Court of Appeal's powers, Article 26 2A provides that the Court of Appeal may, in exercising its appellate jurisdiction under Article 26.1, make or give any order that could have been made or given by the Court of First Instance or tribunal appealed from. And so, if the issue is, what could you make an order which altered or the findings of contempt or the sanctions, it does appear that you have, as this says, the power to make or give any order that could have been made by the Court of First Instance.
All right, that was my question. Yes, I think.
Yeah. And then if we go on to Part 7 on page 6522, because Mr. Bohr, although he accepts it's not his best point, does rely, I think, on Article 32. Part 7 is headed General, Chapter 1, Practice and Procedure, and so is not purporting to deal with jurisdiction at all. And then it sets out on 32, including injunctions and interim and interlocutory orders. And it says in terms that those orders and directions may be given as to the conduct of any proceedings before the DIFC court. So making it clear, even on its own terms, that this is not purporting to give any wider jurisdiction and that arising under the Judicial Authorities Law, but simply relating to the powers that can be made in proceedings which are properly before it. So in my respectful submission, the court law does not begin to found any wider jurisdiction which is outside the bounds of Articles 5.1a to d of the Judicial Authorities Law. And it is entirely consistent with my submission that the court has power to give injunctions only in cases where one of the gateways under Article 5.1a to d or the gateways in relation to agreement that the court should have jurisdiction under Article 5.2 or 5.3, only where those gateways are satisfied does the court have a power to make an injunction against a party.
Can I just ask, you keep on specifically saying A to D. Do you not E where it applies?
Yes, I'm only saying missing out E because in my submission, no one's identified any other grounds of jurisdiction which would come under E that would be relevant to this.
I see.
So, perhaps I should have put this question to Mr. Ball. That I just realized that as Mr. Libita was speaking just now, that we don't have to go beyond the UAE. If a party from Abu Dhabi or from Al Khazaima comes to the IFC and seeks for an injunction for something that's happening in Abu Dhabi or Al Ain or somewhere else, I don't think we would have entertained that sort of application. The courts in the Abu Dhabi, or rather the people in Abu Dhabi, is not going to like that at all. You know, you come to and say that under this jurisdiction, you have a right to issue an injunction against so and so in Abu Dhabi. You know, that's what basically is happening here. Except that it's Kuwait and England, or rather US and Cayman Islands. But you don't have to go that far. Just go to Abu Dhabi or Ras Al Khaimah.
You can say further, Chief Justice, we do not accept cases from Dubai itself unless parties has opted in to this jurisdiction, and that fall under JAL again, because the JAL would give Dubai parties themselves, if they want to bring their cases under this umbrella, has to opt in.
Okay. Yeah,
Can I respond to this?
Yes, Mr. Bo?
Or I can do it at the end if you like.
Yeah, well, yeah, let's wait. Okay. Or you want to answer now before you forget? Okay. I mean, Mr. Libita, can you give way to Mr. Bo?
Yeah, of course.
To answer.
I'll just deal with that one particular point. I mean, in the case that you say, where there are issues of comity, the court, of course, wouldn't grant an order in favour of the Abu Dhabi party. The court would have jurisdiction. In our case, the court would have jurisdiction to do so because the jurisdiction to make interim orders is unqualified. But it wouldn't do so if there was going to be issues of quality and comity and indeed other issues. I mean, it has to satisfy the good arguable test of all the other tests. It's only in a case where it's right for it to do it, and it's expedient, to use the language of the English courts, to do that. So I accept that, and that's the guard against these kind of things happening. Yeah. But in this situation,
there was the same argument in respect of Brazil and all the other states that put in earlier.
Just to add one sentence to that, in this case, we're not trampling over any other court's jurisdiction, because in the case, I think it was in Jones, I think there was an issue because there were Dubai proceedings, and there was a question whether the Dubai court should be making the order. But I believe that the judge nevertheless in the DIFC made the order. But we don't have that conflict in this situation because there's not the JJC issue of conduit, because the Dubai courts haven't taken jurisdiction. It just happens to be there are assets there, and we're using this court as an international court in an international case to assist us when there is a link through the conduit, and it's a potential anticipatory link. I'll stop there and give way to Ms. Libita.
Thank you very much.
No, I wonder why you say this is an international court. What make us an international? Yes. We're not the International Court of Justice.
Dubai International Financial Center Courts. No, just joking. Please answer. Yeah. Yes.
I think what makes it an international court is it has regard to international case law and international practice in a way that the local Dubai courts doesn't have, and it has also set itself up to establish like procedures and frameworks which have been based on the English commercial court It has judges with great experience in commercial cases which don't just involve the DIFC, but other jurisdictions. And it attracts people from all around the world to use the facilities because of that knowledge and expertise, and because of the efficiency and the robustness of the decisions. And that's the reason it's an international court.
But you still, the English High Court's not called international one. You didn't have the Supreme Court of Singapore calling itself, and we are an international as well.
I would say that the London Commercial Court is an international court. It doesn't use that term because it happens to be a national court. There's been no carve out in terms of a financial centre, but my understanding, and excuse me if I'm wrong, is that the DIFC aspires to be similar in the terms of how it operates.
I
The
think
Americans are not going to be happy with that statement, Mr. Moore.
I think the word,
Yes,
I think the word,
yes.
I think the word international is used in argument to try and suggest that the court should be expansive and cover all aspects of jurisdiction.
Well, I've used it in slightly different ways. When I talk about the court itself, I mean in terms of the processes. In other words, there seems to be particular processes that seem to be common among the big commercial courts around the world. I'd say nothing more than that. When I'm using it in terms of justifying the application, I'm simply saying there's no one center of jurisdiction. We're dealing with a situation where there are cases in different jurisdictions, assets in different jurisdictions, and people traveling in different jurisdictions, and that's my point. Okay.
Yes, Mr. Libita, can you continue?
I'm grateful. So it's a point of great importance. The suggestion that the DIFC court does have an international jurisdiction over everybody everywhere, which is the precise consequence of Latif and Jones, it is an extraordinary one, because it would completely trample all over the very careful delineation of jurisdictional issues within the UAE, and particularly between onshore, so-called onshore and offshore courts. And it would be a matter of great surprise, I think, to anyone in Dubai if the DIFC court was held to have jurisdiction to issue an injunction, for example, in support of a local Dubai, in support of a dispute before the Dubai courts, in relation to which there was no connection with the DIFC. But that is Mr. Bohr's submission. Now, he says that, well, of course, the court wouldn't exercise its jurisdiction on the grounds of comity. Sometimes he uses the word expediency, sometimes he uses the word discretion, but at no point anywhere in his submissions has he identified with any precision what the basis of what the limits or the delineation of the jurisdiction would be, or how that would be exercised in a principled base. And I will come on to this in a moment. That the reason in my submission he hasn't done that is because that he knows that as soon as he looks at the checklist set out in paragraph 27 of Mr. Justice Popplewell's decision in ICIC against Domenico, which I showed you yesterday, he cannot satisfy any of those tests. In any event, we've looked at the court's law. Can I now look very briefly at part 25, just to pick off the points that Mr. Bohr raised, which I hadn't previously dealt with. Part 25 is page 6562, and I can take this briefly.
Part 25 of what?
Sorry, of the rules of the Dubai court, DIFC court, 6562.
Right.
RDC, the blue
RDC, yeah, RDC, yeah. So Mr. Bohr first of all relied upon RDC rule 25.1, which gives rise to the power to make interim remedies. But of course, these are interim remedies which may be given in proceedings over which the court has jurisdiction. So, for example, in relation to freezing relief, an article in rule 25.16 said to be restraining a party from removing from the jurisdiction assets located there, or restraining a party from dealing with any assets. So that means a party to proceedings within the DIFC court. And we know that. Well, I'll show you. Let me show you one thing, a couple of things before I finish that submission. He also relied upon RDC rule 25.4, which says a judge may make an order for any interim remedy. But in my respectful submission, it's absolutely clear the purpose of rules 25.4 and 25.5. They are to delineate the powers that on the one hand a judge has, and the other hand a registrar has to make interim remedy orders. So 25.4 says that a judge has the power to order an interim remedy in any case, whereas 25.5, the registrar has the power to make interim remedies only in circumstances set out in rules 3.4 to 3.14, which relate to case management. So jurisdiction in 25.4 and 25.45 is delineating the jurisdiction on the one hand of the judge and on the other hand of the registrar, and it does not purport and it does not give freestanding jurisdiction to give interim remedies in any proceedings, against anyone anywhere in the world. Now, 25.7 25.6 and 25.7 are quite important because they deal with the time when an interim remedy may be made, and 25.6 says that it may be made even before proceedings are started. 25.7 then says it can only grant an interim remedy before a claim has been made if the matter is urgent or it's otherwise desirable to do so in the interests of justice. And then, importantly, 25.14 makes it clear that where an application is made for an interim remedy before the issue of the claim form, there must be an undertaking given to issue a claim form immediately, and then that must be done. So the provisions of 25.1 up until I think 25.24 are all dealt with, are all addressing the issue of interim remedies being brought in the context of substantive proceedings under a Part 7 claim form. And we know that because the rules provide that a claim form either must already have been issued or must later be issued. And of course, that means a claim form seeking substantive relief. So the interim remedy sought is in relation to a claim before the DIFC court seeking substantive relief. The importance of 25.24, which I had previously understood to be Mr. Bohr's main argument, but I think it isn't anymore. The importance of 25.24 is that it says that where the interim remedy is in fact being sought in relation to proceedings outside the DIFC, then the application must be made in accordance with Part 8. And that, as I read the rules, is the only provision which deals with interim remedies which are arising other than in relation to a substantive claim before the DIFC court. And that is why 25.24 is a procedural issue. That's why it says that there has to be a Part 8 claim form, and that's why it's important it's there. Now, you already have my submissions that, contrary to the decision of Sir Jeremy Cook in the Jones and Jones case, in my respectful submission, 25.24 has meaning without interpreting it as conferring additional jurisdiction, because a claim may be brought against a DIFC establishment, for example, in a different court for the reasons I explained yesterday. And I don't think my learned friend Mr. Bohr in fact disputes that. Mr. Bohr had what he described as a more subtle point today, which goes back to Article 5, the Judicial Authorities Law. And I'm not sure I completely followed it, but can we just have a look at that? It's page 6622.
Sorry, page what?
Page 6622. And it seemed to be relying upon the fact that Article 5A1E refers to any claim or action over which the court has jurisdiction in a court with DIFC laws, and he drew a distinction between that and the other provisions in Article 5A1. But of course, all the other provisions in Article 5A1A to C also referred to claims and actions. So there's no difference there. The main point, as I say, is that the RDC anticipates under Part 25 that interim injunctions will be brought in the context of what is a substantive claim under a Part 7 claim form, unless it's a claim for an interim injunction in relation to proceedings elsewhere, in which case it must be made by Part 8. But in any event, in my submission, there still must be jurisdiction under Article 5 of the courts of the judicial authorities law. Now, Mr. Bohr's next point was what he described as the anticipatory conduit enforcement point. Now, you have my submission on the execution jurisdiction under Article 7 of the judicial authorities law. That plainly arises only in relation to judgments which have already been issued, and does not arise in relation to a mere cause of action which may or may not give rise to a judgment. The conduit jurisdiction is a completely different issue. As the Chief Justice pointed out, the DNB against Gulf case was a case about the enforcement of a court order. The so-called conduit jurisdiction, which is obviously a matter of some controversy, relies upon the onshore, if I may call them that, the onshore Dubai court's obligation to enforce final judgments under Article 7.2 of the judicial authorities law. Now, in parenthesis, I would say this: it's not at all clear to me whether an interim order, like a freezing order, could be described as a final judgment for the purposes of Article 7. So I'm not sure it even works on that level. But the suggestion that there could be some sort of anticipatory conduit enforcement jurisdiction is, as Mr. Bohr accepted, a novel argument. It's not founded on any decision. Jones and Jones certainly doesn't rely upon it, although it's fair to say that it does say that the DIFC should have powers akin to those identified in broad idea. The decision in Latif mentions the conduit enforcement procedure, but it doesn't seem to rely on it. So Mr. Bohr says, well, you extend Article 7 jurisdiction so that it applies to causes of action and not merely judgments, by reference to the decision in the broad idea case. But the broad idea case was an extension of common law jurisdiction in relation to freezing orders. And I think most people would agree that it was an extension over the previous jurisprudence in the Siskina, which said you needed a cause of action. That is exactly, in my submission, the sort of extension of jurisdiction that courts of unlimited jurisdiction may make. It is not the sort of extension of jurisdiction which could, in my respectful submission, be made in a court like the DIFC with a limited statutory jurisdiction. And again, at the risk of repeating myself, and I try not to do that, just think what it means. It means the DIFC assuming jurisdiction to make freezing orders in support of cases everywhere: Dubai, Sharjah, Abu Dhabi, and outside the UAE as well. That is not a jurisdiction which should be assumed without some clear statutory basis. So may I summarize the position on jurisdiction in this way, as briefly as I can? It's established beyond doubt and common ground that the DIFC court is a creature of statute, and its jurisdiction is created by and also curtailed by the judicial authority law. It's wrong, in my submission, in principle, to seek to expand that jurisdiction by judge-made law in the way that might be appropriate in courts of inherent jurisdiction. The court's law does not give a general jurisdiction to grant interim injunctions against anyone in the world. It merely states the jurisdiction to grant injunctions which arises in cases which fall within relevant gateways, and the same applies to Part 25 of the RDC. As for enforcement, that jurisdiction only exists in relation to judgments that have been issued, and therefore, in my respectful submission, the juridical basis of the decision in Latif and in Jones and Jones and in the judgment which is before you is unsound, and those decisions should be overruled. As for the powerful appeal to policy made by Justice Sir Jeremy Cook, the court should have have this width of jurisdiction. Well, in my respectful submission, that is an appeal to policy which should be made to the lawmakers. And if they think it is appropriate that a wider jurisdiction should be given, then the way to do that is by amending the judicial authorities law, subject to appropriate limits. So in my submission, there was no jurisdiction at all to make this order, and it should fall away. Next, could I turn briefly to issues which I might describe as expediency? So Mr. Bohr has met some of your questions this morning in relation to how can it possibly be the case that the jurisdiction is so wide, by saying, well, of course, a judge wouldn't exercise jurisdiction if it trampled upon issues of comity, or if it was exorbitant or something of those sorts. But he has not identified at all with respect to him. He's not even sought to identify what the basis of those limits might be, or how they arise under the Judicial Authorities Act. If, for example, you found that the decision was the Dominico test that I set out yesterday, then that they would fail that, because there is no connection at all to the DIFC. So that was all I wanted to say on expediency. Turning then to the issue of whether we should have been heard by the judge, notwithstanding the contempt. In my respectful submission, I don't think I need to add very much to what I said yesterday, just to make it very clear. And I thought I'd made it clear yesterday, but perhaps I hadn't. We do say that the judge's exercise of discretion was wrong in principle in relation to his refusal to hear us, because he failed to give any, or certainly any adequate weight to the point that it is necessary for the purposes of justice to hear a party who is accused of a contempt on why the order should not have been made, not just on the point of narrow jurisdiction, but on all the points that they want to make, because it is necessary to hear what the alleged contemner says in his or her defence before you find them in contempt, and certainly before you issue a sanction. The only point of distinction between us and USAM was the timing at which applications were made. And in my respectful submission, to say that the fact we didn't make our applications in time means that we're not entitled to be heard, it is to put procedure over justice. And it is appropriate in my submission to judge it on the assumption that the order should not have been made. If the order should not have been made, it is not right as a matter of principle in my submission to find someone in contempt because they didn't make their application to set aside early enough. Now, if I think yesterday the issue was raised on the basis
Mr. Libita,
yeah,
that was what Motorola held, that irrespective of whether if you breach the order of the court, respective whether the court had jurisdiction or not, you are liable for contempt, because otherwise you face this problem of parties not respecting any court order.
Yes, so I'll come on to that in a moment if I may, but yes, in the Motorola case, the court found that because the English court has essentially unlimited jurisdiction, although the order should not have been made, as they found, against two of the defendants under the principles under the Section 25 of the Civil Judgments and Jurisdiction Act, that they upheld the finding of contempt. Now, in my submission, where in the current case, the DIFC court, if you find that there is no jurisdiction at all to make the order in the first place, in my respectful submission, the finding of contempt should fall away, because my client should not have been troubled at all by anything to do with the DIFC court.
Wasn't that what happened in Motorola?
No, because in
the court
Motorola
had no jurisdiction to make the winding up order at all. What difference does it make here?
In Motorola, which is the case I think we're talking. So there are two different cases. There's a Privy Council case called PwC against Sard Investments, which is a winding up order, which I don't think there was an issue where the court said that orders in relation to winding up should be made. I don't
Yes.
think it was so I think probably we're getting into semantical difficulties again about what jurisdiction means.
Yes. Yes.
And in the case of PwC against SAD Investments, they were talking
Yes.
about a court of unlimited jurisdiction, which certainly had jurisdiction to make winding up orders. But the finding there was that on the relevant statutory power, that should not have been issued. That should not have been wound up. Now, whether you describe that as an issue of jurisdiction or an issue of power or otherwise, the Privy Council was there saying that where you have a court of unlimited jurisdiction, then orders must be obeyed. And that was the same point made in Motorola against Uzan, which
Yes.
where the Court of Appeal said, well, the court had jurisdiction to make the order, and this is paragraph 150 of the judgment, had jurisdiction to make the order over all the defendants, but the Court of Appeal said that it was inexpedient to exercise that jurisdiction in relation to the second and third defendants. That's paragraph 150. So therefore, the contempt was upheld. Now, in my respectful submission, in the context of the DIFC court, a court of limited statutory jurisdiction, in the event that there was no jurisdiction at all to make the order, which is my primary submission, then it should also be the case that the finding of contempt would fall away.
I think to be fair, Mr. accept that.
Yeah, I understood him to accept that as well.
Yeah, but there's what is the distinction? You know, that's what's bothering me is where the court doesn't have jurisdiction at all, as if it doesn't exist at all. The other one, it exists, but in respect of that particular subject, it doesn't have jurisdiction.
Yeah.
I mean, recognize there's a court, but when it comes to winding up, he doesn't have the power to wind up. Here you are saying in the context of the IFC, it's as if the court doesn't exist. It cannot make any order at all insofar as your clients are concerned. You know, there's some, in my mind now, there's some minor or rather defined line between the two, but I'm not sure how to describe that yet. Yes.
Yes, well, it is primarily a matter of the court, and I feel a degree of reluctance to make submissions to judges of a court in relation to how precisely they construe their jurisdiction and how precisely they deal with issues of contempt. But in my respectful submission, that I think Mr. Board did accept that where an order is made,
yes,
which should never have been made at all, and there's a nullity, essential jurisdiction, then that contempt should fall away. That's my primary submission. Now, there was an issue raised yesterday about whether, and I wasn't sure whether it was necessary in the context of the freezing injunction or the findings of contempt or both. But if the court was to find that there was prima facie essential jurisdiction, but that the judge should have permitted us to be heard on all issues, either before continuing the freezing injunction or before making the findings of contempt, what should then be done? And Mr. Bohr said, well, you should remit it back to the judge for new findings to be made. Now, in my respectful submission, my primary position is that if that was your position, then you should discharge the freezing injunction because it should not have been made. And you should set aside the findings of contempt because really in the context of this case, it doesn't really do, they don't really serve they don't really do anyone any good. If you were minded to remit it to the judge, though, I would respectfully suggest that because on that assumption, you would have found that His Honour Sir Jeremy Cook, Justice Sir Jeremy Cook, had obviously unwittingly and without intending to, but nevertheless had conducted a procedure which was unfair, it would be appropriate to remit it to a different judge, because in my respectful submission, it would not be appropriate for a party who has been found in contempt by a judge and then the Court of Appeal has said that the procedure which led to that finding was unfair, it would not be right to send it back to the same judge. It wouldn't be right to my clients, and in my submission, it wouldn't in fact be right to the judge either to do that. So if you were to remit anything, then it should be to a different judge, in my respectful submission. But of course, that's very much a secondary or tertiary position, because I say that the order shouldn't stand at all. Finally, then, in relation to some of, no, not finally, but the next in relation to whether the freezing injunction should have been made, I'll take this very briefly, because I think that the issues have been argued and certainly set out in writing in some detail. Just to make it clear, we don't give up any position on the fact of a material change of position in relation to the fact that these various different proceedings around the world are all failing one way or another. Indeed, I would submit that now we have the expert determination in Kuwait saying that the claim is hopeless. If this matter continues beyond this appeal for whatever reason, we would be entitled to apply to set aside the freezing injunction on that basis. Just to be very clear about the position in relation to other proceedings, first of all, I note and just put on the record again, my learned friend Mr. Bohr is very helpful, and if I may say so with respect, correct concession, that if the cases in Kuwait and France are dismissed, then any contempt would not prevent the defendants coming to this court and asking for the order to be set aside, and I put that on the record. In relation to the French proceedings, Mr. Bohr said there is on foot a French claim. We need to be a bit careful about that. The criminal claim has been rejected by the public prosecutor on the 23rd of November 2022. That's page 256. No permission has yet been received from a French judge, who apparently is known as a dean, to pursue any further claim. And as things currently stand, the French judge has indicated that the French courts do not have any jurisdiction. And I take that from Mr. Nouri's own French lawyer's statement, Monsieur Savoy, paragraph 2.25, page 6094. In the French claim, there are a number of florid, this is the French claim that currently stands dismissed, at least in terms of the criminal procedure. There are a number of florid allegations in relation to forgery, fraud in an organised gang, and all sorts of other things. I have no idea where they come from, and I don't think that Mr. Bohr made any suggestions about those claims when he put the case in the DIFC. This morning, Mr. Bohr made an allegation that the claimants have what he described as a beneficial interest in property transferred out of UEL pursuant to the CPUIT and Metanic transactions. I don't know what basis it is said that there is a beneficial interest, what law is said to apply to give rise to a beneficial interest, on what basis it is said that fiduciary or trust principles arise. In relation, he showed you the joint official liquidators initial report. They, of course, as you know, were liquidators appointed by Mr. Nouri on his application. Sorry, they're appointed by the Grand Court of the Cayman Islands, but on Mr. Nouri's application, and joint liquidators who he nominated, who said there were things to be investigated. Fine. They've had time to investigate them, and I think we understand they have investigated them, and no claims have been brought. Quantum. Mr. Bohr accepted ex parte in argument before the judge that quantum was speculative. The quantum figure, in fact, put in the freezing injunction was based, as I understand the transcript, on a procedure, on a quantification suggested by the judge rather than Mr. Bohr, which started with a valuation of the company in 1999 of $166 million, and then uplifted by some fairly high-level arithmetic during the course of the hearing. But at no time did Mr. Bohr explain why a valuation of the company in 1999 could possibly be relevant to a claim specifically relating to two transactions of assets of that company made out in 2014 and 2015. Doesn't even begin, in my respectful submission, to amount to a proper claim. Mr. Bohr also referred to criminal allegations that have been made against Mr. FAWZI on behalf of Mr. Nouri, his brother in Kuwait, which I think yesterday Mr. Bohr rightly agreed to be irrelevant. If I may say so, and I fully accept you're not going to be in a position to make findings about this, but I make this as a submission in any event. What we see in this case is a classic pattern of behaviour of the serial vexatious litigant who brings proceedings all over the world, all the time, for all sorts of issues, and all that you can deal with when you're at the position of the defendants, in this case my clients, against this sort of serial litigant, is to try and deal with them as best you can. Now, that is not, of course, a finding you can make, but in my respectful submission, it does at least explain some of the reluctance to get involved as early as they might with the DIFC court, because they just have this time and time again, and they've had it time and time again over the last 25 years of proceedings being brought all around the world, none of which get anywhere. So finally, then, in relation to contempt, and I apologise for dealing with this in a slightly dotty way, I've made my submission, my primary submissions in relation to contempt. The cases of Paratus and Merchandani, which Mr. Bohr referred to this morning, were both English domestic injunction cases involving defendants within the jurisdiction. If you decide there was jurisdiction, if you decide there was no jurisdiction to make the order, it seems to be common ground that the finding of contempt must fall away. If you decide there was jurisdiction to make the order, but it should not have been made, I would submit that the contempt finding should also fall away, but in any event, the sanctions should be removed. The sanctions have certainly been appealed, and they are grounds 31 to 34 of the grounds of appeal. My learned friend Mr. Bohr said there was no authority that the fact that the order should not have been made is relevant to sanctions. Well, yes, there is. It's the Uzan case itself, where although the Court of Appeal found that the second and third defendants against whom the orders should not have been made were still in contempt, they allowed the appeal against the sanctions in paragraph 156 and remitted that to the judge for further consideration. I've spent quite a long time reviewing that case and trying to go through the different decisions. I haven't actually managed to find what in the end happened to those two defendants in relation to sanctions. In any event, the reasonableness of the defendants contending that the orders should not have been made must be highly relevant to any sanction. So I do say, by way of final submission, the freezing order should be set aside, the findings of contempt set aside, and the sanctions, and we should be awarded our costs, with the sum standing in court being returned to us. But unless I can assist you further, those are my submissions.
Thank you very much. Any questions from?
Just one question, if I can. You mentioned at the end of your first submissions that you wanted an order for an inquiry as to damages on the cross undertaking.
Yes.
Is that really a live issue? Because you, by all accounts, you haven't done anything to obey the order, and therefore it hasn't stopped you doing.
Well, I think probably the way to leave it is that it would probably have to be made it would have to be an application made to the Court of First Instance in any event, rather than the Court of Appeal. So I think probably on reflection, it's something which could be left to another day if that ever were to be the case.
Yes, thank you.
Anything else, Mr. Bohr? You want to say something?
If I'm allowed to respond to some points, I don't know whether I am, given an appeal, but I do have some points in response, if I may make them. So it's up to the court.
If you think they're very important, they're very relevant to your case.
I think they are quite important. I'll try and take them very quickly. I mean, the 25.24 point. My learned friend said he doesn't understand them. So I understand the point I made, and I apologize if I wasn't clear. It is a subtle point, but I think it's a powerful one. What 25.24 says that the court it suggests, I should say, so we're using it only as a support, that the court has power to make an order in support of foreign proceedings. The point that what we would make is that can only be the case if there are foreign proceedings, clearly, or they're about to be foreign proceedings. It wouldn't be the case if there are proceedings before the DIFC, because then the DIFC can make its own injunction. Because there's no proceedings before the DIFC, then the JAL 1A A to D cannot apply. because there's no proceedings, call it an action, call it commercial claim, whatever it is. There's no proceedings before the DFC, and therefore it follows that the party making an application for an injunction in support of foreign proceedings must, this must follow, be relying on JAL 1AE. And that's the point that's made in Latif, and the analysis I've just gave is my understanding of it, and it's our submission. And I think that's a very powerful point. And then the question is, well, where is the jurisdiction? You asked this point. You say it all comes back to the JAL. The Chief Justice made this point. And but we must keep in mind that the JAL has in itself a reference to other laws and regulations. So it's true everything starts with the JL, but JL 5A1E refers to laws and regulations. If in fact everything is in A to D, then E would have no effect. So the court can look, and of course must look at to see if there are DIFC laws and regulations. And the court law is clearly a law, and it contains a section which is headed jurisdiction. And in that section, there is a statement that the court can make orders as appropriate. And I'm going to come back to that word in a moment because it's a very important word. It can make orders as appropriate. And we say, given the context of it, it is clearly there to deal with jurisdiction, not only because it's in a section headed jurisdiction, but because also there is also an Article 32 which deals with interim remedies, which as discussed may well be about power. So if that's about power, why do we have Article 22, which is also about power? We say the only purpose of 22, it must have some other purpose than just power, and indeed its purpose is jurisdiction, and that's the point that we would make in our response submissions. In relation to 25.4, my learned friend says, well, the judge would have, it's an extraordinary submission to say that it gives jurisdiction in an unqualified way, but that provision begins with a heading saying jurisdiction, so it does exactly that. But it's not completely unqualified, because one has to look at Article 22. It has to the jurisdiction has to be exercised appropriately, because Article 22 says as appropriate, and it's the words as appropriate which mean that this court will not make orders which trespass against on comity, or that there's no link whatsoever with the DIFC, and or other factors. Now, my learned friend says we haven't told the court how discretion is to be exercised. Well, firstly, with respect, our first point is that discretion shouldn't be an issue for this court, because the judge was right in saying that discretion that's already gone. And the second point is that that's never really been clarified by the courts. The cases below simply say that the discretion has to be exercised appropriately, and that takes care of the fairness issues and the exorbitant issues. But I do say, as a matter of submission, that the court can have regard to the ICCI case, which my learned friend brings, and can have regard to the ESSA case that I took you to, which says that when you are dealing with serious wrongdoing, then the court can take a much more generous approach than the previous authorities or other authorities suggest. And I do say, and this is important, of course, that in terms of that the conduit jurisdiction does give a connection to the DIFC, which takes it outside the ordinary. Now, my learned friend says, and again, this is why this point is important, he seems to link the freezing injunction to the conduit jurisdiction. That's not my point at all. My point simply is, this court will have a right to enforce a judgment from Kuwait or France at some point in the future. Point number two, the purpose of a freezing injunction is to secure assets pending a future judgment. And so point number three is applying and that's the enforcement principle and broad idea. And so point number four is the court can exercise its very wide jurisdiction to protect those assets pending an application to enforce a judgment in some point in the future. It has jurisdiction. And we say that makes complete sense with the Latif Jones cases, it makes sense with the broad idea cases and the international practice. And so those are really my points on the jurisdiction. In relation to the submission to the jurisdiction, very, very quickly, my learned friend, we do accept, makes the point about that you can't submit to jurisdiction which the court doesn't have. And again, we submit that goes back to the essential jurisdiction point. It is true that someone cannot submit to jurisdiction when the court doesn't have that. And the key words in the case that he took you to are the words, according to national law. And so, indeed, issues of, and it mentions comity specifically, but so we would say subject to comity in essential jurisdiction, as long as a court has that, then a party can say, I'm not going to take any issues in relation to discretionary points, points in relation to merits of a case, for example, or risk of dissipation. And so failing to to challenge jurisdiction and failing to put in an acknowledgement of service does have that effect. But in addition to that, in this case, we have the failure to put an acknowledgement and the 12.1 points. We also have the G point, and that is that you're expected to bring forward your case. You can't just sit it out and then try and have matters reheard unless there's been a material change of facts. And what my learned friend says now, just in closing, is that the material change of facts are the things that have happened since, in fact, I think some of them have even happened since the permission to appeal was given, but certainly since the Mr. Justice Cook's judgment. Well, that is a separate issue. If there have been a material change and my learned friend wants to apply to set aside the order due to the material change that has happened since the Cook judgment, then he's welcome to do that. We'll take whatever points they're open to us to take. But that's not an issue for this court today. The issue is simply whether there was a material change at the time that Mr. Justice Cook heard the case, and we say that there wasn't, and I don't believe that's part of my learned friend's appeal. But if it is, there wasn't a material change. I believe that's all my points, and thank you for giving me this this time to respond to those.
Thank you very much. Okay, one question. How urgent is this? How urgent do you require a decision from us? It's quite complex, It's not something. So, well, is there any need for urgency of the?
I mean, it is a case where the impact of the contempt findings and sanctions is a matter of concern and importance to my clients, but albeit without instructions, I'm relatively sure that they would say that they would rather you took the time that you need for the judgment than to rush it out.
Yeah, it's not as if you cannot carry on your business because the injunction is pending, things like that, isn't it? I mean, it's just the way I see it. There's, it's not like American Dynamite where you have to make a decision quickly. Yeah.
No.
So, Mr. Baugh?
The urgency from our side that I can see is only because, as I mentioned at the outset of my submissions, I believe that the hope is that we apply to enforce the WFO within Kuwait. And the issue there is that given this appeal, it's being perceived as not being final and as necessarily final as it should be. But other than that, I agree with what Mr. Leavetter says. Of course, the court should take whatever time it needs, and we'll do so regardless of what I say.
Okay, thank you very much indeed. Any questions from the judges? No questions? Okay. And we leave. Thank you very much for your very enlightening submissions on both parties. I'm sure it would help us in arriving at our position much earlier, easier, with your very frank and very deep arguments put in.
I'm grateful. Chief Justice, can I just mention one thing that I've just been asked to by my solicitors in relation to costs? I mean, clearly that's something further down the line, but we'd ask to make some submissions on those and be given that opportunity in due course.
Your separate submission, okay?
Yeah.
Take the submission on cost. Okay, so we'll leave this link And can I have a few minutes with the judges on the other link?
Yeah, sure.
Judge Ati, okay. So thank you very much indeed.
Thank you very much. I'm grateful.